And your point yesterday was that this money was a reward for the killing.
Well, SAPS did not say it's for the killing, but in essence it is for the killing, because according to them, how they say they've quelled taxi violence, we know it was through the killing, according to evidence of witnesses.
No, I think you are wrong on that, because if you go to page 32.
Okay.
One, two, three, the third paragraph.
Okay.
There they say, this is to explain why these people are getting their rewards.
Okay.
Dumisani Ndlovu was shot by Inspector Kanyele, one of Superintendent Chonco crew. Lindane Buteles was shot by the investigating team. Natim Tembu was shot by the investigating team. Mdu Kolopoto Nduli was shot by the investigating team, who was also wanted in Mapumulo case 0202-2005. Timson Magoja Landimade and his bodyguard, Sibusiso Tembe, were shot by the investigating team and who orchestrated the hit on Superintendent.
Oh, yes. Yes, on this basis, yes.
Yeah, so they themselves say this is for the killing.
Yes.
Yes.
Counsel, where were you reading?
Page 32, the third paragraph.
32.
Yes.
Yes, they are not saying it was for their arrest through legal processes, and true, I get the point.
Yes. And now if you look at who these members of the investigating team, they are all explained in that document at page 31.
Yes.
And in the second sentence,
yes, I see.
that is just one group. The investigating team, which at this stage consisted of Inspector Mostert, Nell, and Makany, in one vehicle, while Captain Van Tonder, Lockham, and Eva, who followed in a separate vehicle.
Yes.
Those are the members of the investigating team.
Yes.
Who they say must be rewarded for killing.
Yes, I see that. Yeah.
Yes. Now, we're then at page 28.
Okay.
Yes. Now, these are more members that must be rewarded for playing a part in the killing.
Yeah.
Yes. Now, what is the name of the first candidate to be rewarded?
It's Director J.W. Boison.
Yes. And there are, I counted 19 members there.
Okay. It's 18 on the first page, on page 28, and 3 more.
Yes, 18 on the first page, and then
3 more on page
19,
29.
20, 21.
So it's 21, yes.
Yes. Now, these are from Cato Mano.
Yes.
Yes. But look at what is being said about them. Why should they be rewarded? In the second paragraph of page 29,
Yes.
after the names. Can you
Yes.
read that?
Yeah. It says, each of the above candidates played a role in the successful apprehension of the suspects. Some of the candidates played a role in the apprehension of the suspects, while others assisted at the scene.
Yes. Now, we know as a fact that no suspects were apprehended.
Yeah.
All of the suspects alleged suspects that are referred to were shot and killed.
True.
Yes. Now, they themselves say each of these candidates played a role.
They are associating themselves. Yeah.
Yes. And then they say others came to the scene. Yes. But that includes General Boison.
Yes, we know in most of the scenes he was called, according to Mr. Danikas.
Yes. Well, his name is mentioned by the SAPS, where they say he is one of the people who played a role.
Yes.
Yes. Now, the same point is made at page 34.
Okay.
Yes. Which appears to be a motivation later on the 18th of November 2008.
Yes, I see that.
If you look at page 42, it's signed by a Mr. Vessels or a Miss Vessels or Mrs. Vessels, who is the provincial head of personnel services in KZN.
And where is
Oh,
that,
yes.
Council?
Page 42,
42.
in the middle. Yes, Madam Chair.
Yes, I see that.
Yes. And then endorsed at the bottom by the provincial commissioner, Mr. Ngidi or Miss Ngidi.
Yes, I see that as well.
Yes. But the point of substance at page 34, the details of the candidates to be rewarded for the killing.
Yeah.
What is the first name there?
Director J.W. Boison.
Yes.
Yes.
And then the rest of those candidates, we know that they were all accused in the Ketomano killing case.
Yes, they are.
Yes.
Are these the listed candidates at
Yes, Madam Chair.
28 or at 31?
34.
At 34.
Yes, 34. So the point, Advocate Noko, I was making about the internal SAPS documents
Yes.
that were generated before there was a charge,
Yes.
is that they serve as self-standing evidence
Yes.
that the SAPS itself admitted
Yes.
that these members had shot people and they were being rewarded for shooting those people.
Yes, it appears so, yes.
Yes. They included General Boison as a participant.
Yes,
Yes.
true.
And that's what you were talking about when you said that there was a system of rewarding the killers.
Yes.
Yes. Now, yes, my learned friend points out that if you go to page 33, it looks like that was supposed to be signed by General Boison, but his name is scratched out. And then it is signed by the provincial head of detectives,
Yes.
who is Brown,
Commissioner Brown, yes.
Commissioner Brown.
Yes.
Yes. But in any event, General Boison did sign the document at page 27.
I beg your pardon, do we know for certain that this is General Brown's signature?
Perhaps do you know for certain?
I don't.
Yes.
Because I cannot
I don't.
make a head or tail of this signature.
Yes.
But I see in the handwritten words is Provincial Head Detective Service, KZN.
And General Boison was not the head of detectives.
Yes.
Yes.
We learned yesterday what rank he was holding.
Yes.
And who is this Provincial Head Detective Service, KZN? Who could it be?
Commissioner Brown, according to what we have in the Kachomena case, was superior to General Boison. He was reporting to him then.
He was listed as the provincial commissioner, KZN, as we read from that list
Yes.
of yesterday.
Yes, something like that, yes.
Yes, Madam Chair, you are correct. He's the Assistant Commissioner of KZN.
Okay.
So that appears at page 27. So at page 27, he is listed as the Provincial Head Detective Services, Assistant Commissioner P.T. Brown.
Yes.
27, Council?
Just under the date 15 October 2008 on the right.
Yes,
Yes.
precisely.
Yes,
Thank you.
yes, so that's correct.
Okay.
And then at the bottom of that page, that's where General Boison himself signs.
Yes.
Yes. So any claim by him that he was not aware of this system of rewarding the cops for the shooting would be false by General Boison.
Very false.
Yes. Now, can I move on then to another topic? We finished the internal documents, which you said you had read at the time.
Yes.
Yes. I want to take you to the documents that start at page 43.
Okay, I have it.
Yes. Now, you would recall that yesterday or the day before, I can't remember, you gave evidence that the attorney,
Mr. Shozi.
I thought he was Hlapane,
Hlapan is the name of the firm.
or the attorney himself is Shozi.
Yes.
All right, I understand. So Hlapane attorneys brought an application on behalf of Mr. Mkhize,
Yes.
in which Mr. Mkhize said, I have heard that my name is in a hit list
Yes.
and I want an interdict
Yes.
to prevent being...
Yes.
Yes. Yes. Now, these are the papers in that interdict. At page 43 is the notice of motion,
Yes.
and the relief that is sought is at page 44.
Yes.
And paragraph B, Roman figure 1, speaks
Yes.
directly to what you said,
Yes.
where you said that it was an interdict against being killed, where you said that the respondents be interdicted from killing, injuring, threatening, harassing, or in any way intimidating the applicant.
Yes.
Yes. And then paragraph Roman figure 2, ordering the respondents to receive the applicant from his lawyers, thus effecting the warrant of arrest in the presence of the applicant's legal representatives.
Yes.
Yes. Now, which is also an extraordinary thing where a suspect says, I want a court to order that the police must receive me with my attorney. Because that's what the police are expected to do anyway.
It was out of desperation.
Yes. Now, the fourth respondent in that application, who is he?
Fourth respondent.
Yeah, fourth respondent.
Oh. It's Organized Crime Unit, SAPS. Oh, okay. Commissioner J. Boison,
Yes.
Head of the Organized Crime Unit, SAPS KZN.
So again, Major General Boison is specifically cited.
Yes, and he deposed to an affidavit
Yes.
to say Mkhize won't be harmed.
Yes. Now, let's just deal with that. You say that he deposed to an affidavit. There is an answering affidavit
Page 69.
At page 69, thank you. And who is the deponent in that answering affidavit at page 69?
It's Johan Vessel Boison.
Yes. Now, there are only two parts of this affidavit I would like your comment on.
Okay.
Yes. The first is page 56, paragraph 24 of the founding affidavit.
56.
Yes, paragraph 24.
Okay, I see it.
Yes. Now, they are talking here about Moses Dlamini. And
Yes.
it says Moses Dlamini was released after it was found that he could not be inculpated with the murder of Superintendent Tongo.
Yes.
As a result of the information I received from Moses Dlamini, I became concerned for my well-being, that's Mr. Mkhize,
Yes.
and approached the association's attorneys, Tlhapane attorneys, and instructed Ngosinade Hopewell Shozi, a practicing attorney of this honorable court, to intercede in the matter on my behalf. I annex here to marked B a copy of the letter written by Mr. Shozi in this regard, wherein I am specifically mentioned in paragraph 11 thereof, as paragraph 24.
Yes.
Remember that we started with that letter.
Yes.
That was the letter of the 5th of September,
Yes.
which sets out everyone who had already been killed.
Yes.
Now, General Boison responded to that paragraph at page 76.
Yes. I have it.
And then he says, I admit that Moses Dlamini was released. Any information received by the applicant from Moses Dlamini, as referred to in the founding affidavit, is hearsay and ought to be struck out. I have no knowledge as to why the applicant became concerned for his well-being and deny that he had any reason to be afraid. Remember that the allegation is that Moses Dlamini could not be linked to the murder of Superintendent Tongo.
Yes.
Does General Boison deny that he could not be linked?
He doesn't.
Yes. And then the letter itself, to show that he was aware of the letter. He says the letter, Annex B, needs to be placed in context. On 5 September 2008, Tlhapane attorneys addressed inter alia the provincial commissioner. A copy of that letter is annexed here to marked JWB1. This was responded to on 11 September 2008, a copy of which is annexed here to marked JWB2. Annex B to the founding affidavit was then received. In any event, in the absence of an affidavit from the author of the letter, the contents thereof are hearsay. So again, it's clear that he is aware fully of the letter, and he was aware at the time it was received.
Yes.
Yes. Which means he knows the narrative of all of those systematic killings
Yes.
that were contained in that letter.
Clearly so, yes.
Yes. He also knows of the allegations of torture that were
Yes.
contained in the letter.
Yes.
He also knows that these were innocent victims of the torture and the murder.
Yes.
Yes. Then, if you go back to the founding affidavit, we were at page 57.
Okay. Yes, I have it.
Yes. Now, at paragraph 25, there are specific allegations made.
Sorry, page 67? Oh,
57.
oh, I was at 47. Okay. Yes.
Yes, at paragraph 25.
Yes.
Yes. where the attorney, Mr. Mkhize, makes specific allegations. He says all of the people whose names appeared on the list referred to above. Now, that is the hit list in the letter of the 5th of September 2008.
Yes.
Have since been killed by the police. Those
Yes.
are the leaders of KwaMaphumulo Tax Association.
Yes.
It was alleged that they were being arrested for the murder of Superintendent Choncho and were killed whilst allegedly threatening members of the SAPS during or shortly after such arrest.
Yes.
All of these deaths have occurred under questionable and suspicious circumstances, and I have been reliably informed by certain members of the SAPS who are close to the investigating team that the policy being adopted by the investigating team is to kill or eliminate all members of my association suspected of involvement in the murder of Superintendent Choncho.
Yes.
Yes. Now, look at how Major General Boison evades these allegations, which is at page 77.
Okay.
Yes. Paragraph 28 of his affidavit, at paragraph 25.
Okay.
He says, I deny the allegations contained in this paragraph. I don't know if you have any experience in civil litigation, but this is referred to as a bare denial.
It is.
Yes.
Even in criminal.
Even in criminal,
It's
okay.
bare denial.
Okay.
Yeah.
Okay. And then it continues. It is not the intention of the police to kill anyone. It is certainly the intention of the police to properly investigate all crimes and to bring the persons responsible, therefore, to book. But he never, ever engages with the allegations at all,
Yeah. Yes.
of which we have established in the previous paragraph that he is aware of them.
Yes.
He was aware at the time the report was made.
Yes.
And what makes it worse here is that more people were killed after the demand was made.
Yes. Didn't stop.
Yes. Now, then there is also an allegation at paragraph 26. Now, you will remember that Mr. Choncho was used as a justification for these murders.
Yes.
And your evidence was that actually Cato Mano know who killed Superintendent Choncho. The Cato Mano members know who killed Superintendent Choncho.
They know.
Yes.
In collusion with the members of the Stenger Taxi Association.
Yes. Now, paragraph 26 addresses that point you've just made. Paragraph 26 of the founding affidavit.
Yes.
It says, I pause at this stage to state categorically that I was not involved in the planning or execution of the plan to murder Superintendent Choncho and was surprised as everybody else when his death was publicized. I was of the view that Superintendent Choncho was doing sterling work in order to arrest the violence and restore the situation of normality within the association's working environment, and his death was viewed as a great loss by me for this reason. I, however, believe, because I've been told as much by a policeman close to the investigation team, that the investigating team in the murder of Superintendent Choncho have taken the view to falsely implicate prominent members of KwaMaphumulo Tax Association in the murder of Superintendent Choncho and thereafter to eliminate them. Rumor is that they have taken sides with the Stenger Tax Association in weakening the KwaMaphumulo Tax Association in the dispute.
Yes.
One of the methods employed in weakening KwaMaphumulo Tax Association is to kill its leaders.
Yes.
Can you comment on that?
It is as the witnesses say.
Yes.
Mr. Matonzi, Mr. Tiani, and the other witnesses who were even tortured themselves.
Yes.
They say there was a hit list of people who are supposed to be killed. It was given to Ketomena after killing them, and then picked some pictures, like Bongizo Mhlongo was sent pictures by Mr. Mostert, who's one of the accused in the Ketomena, to say these are the pictures of Kopolotan Tulu and the other one. And they were paid money. So it was in association with members of the Ketomena, according to the witnesses, to eliminate members of the rival taxi association of Stenger Taxi Association, which is the KwaMaphumulo Taxi Association.
Yes.
So it is true.
Yes. And in fact, General Boison also gives a bad denial. If you go to page 77 at paragraph 29, never engages the facts. He evades the facts.
Yeah. Yes.
Where he says, I deny the allegations. It is not the intention of the police to falsely implicate anyone in any of the crimes concerned. Again, unsubstantiated hearsay referred to in this paragraph is not a basis to grant the interdict sought and ought to be struck out, but never deals with the facts.
And besides, why would you object to an affidavit like this one? Like if someone says, I should not be killed, I should not be harassed, intimidated in any way, why would anyone have a problem with that?
Yes,
Like-
yes. Why would they even oppose it?
Why would you oppose an affidavit like that? Do you want to kill this person for you to oppose it? It's not like an interdict where someone is saying this person, GBV, for example, and say, no, I never assaulted her. But in this one, like, I also saw it, but I didn't understand why would someone object to that.
Yes.
But yeah, that's just my comment.
Yes. Now, then at paragraph 30 of Mr. Boison's affidavit, he says, page 77, the same page where you are.
Yes, yes.
Yeah, just paragraph 30. He also gives a generalized denial. No list existed, and therefore there was no list that could have been supplied to the second respondent. In this regard, I refer to the affidavit of the second respondent filed evenly herewith. Now, the second respondent is the MEC for, page 47.
Advocate Toby, at page 77, paragraph 30, where he denies the existence of a list, he refers to the affidavit of the second respondent.
Yes.
Do we have that affidavit?
No, Madam Chair, I actually looked for it because we had got these documents from the NPA, but I had looked for that affidavit because what we then found at page 87, so if you look at Major General's Boison's affidavit ends at 86. At 87 is the replying affidavit. I had actually looked for the affidavit of the MEC and couldn't find it. So this is something we would have asked for from the NPA, but this is what we got. These are the documents we got called NPA summary.
I think I should find out from the NPA team as to whether we can have the copy of the MEC's affidavit as referred to by General Boison's, that paragraph. We don't have it in our file also. Advocate Haley, let me speak to you directly. I know I should be talking to the evidence leaders, but let me find out whether we can have a copy of that answering of that affidavit.
Madam Chair, as I understand the position, that's what we received from the dockets that were provided to the NPA or within the prosecution team. Thank you, Madam Chair.
Yes.
I'm not sure if this is on. Thank you, Madam Chair. Madam Chair, as I understand it, the position, I might be incorrect, but as I understand the position, when these documents were received, in other words, from the prosecution team that was responsible, they had gone to select documents from various sources. This particular document was presented in this form, but I will try to ascertain or confirm that that is in fact correct. So when we talk about getting documents from the NPA, we must bear in mind that Advocate Chauke is part of the NPA. So that's the source of the documents as far as we're aware.
What do you mean? That Advocate Chauke is the...
So what
he
I'm
said
saying is that
Advocate Chauke is what?
so there was a prosecution team.
Yes.
Advocate Chauke and members like Mr. Mayema or Advocate Mayema, Matenjwa and so forth, what we've been referring to as the prosecution team. They gathered documents which they used to then present the case against Major General Boison. What I'm saying is that as far as I'm aware, the documents that we have in our possession now have exactly these documents over here. But what I am undertaking to do is to confirm whether there was this missing confirmatory affidavit.
Yes. I don't even know at this stage whether it was confirmatory because the MEC is a second respondent. He could have filed an answering affidavit probably. And these are supposed to be public documents filed of record, so it should be easy to get them even from the registrar of the court, the High Court in Durban. If we cannot get them from the NPA. Am I correct?
They ought to be, but we're talking about, someone can go and look for that, and I can give instructions to someone within the NPA to try and uplift the file. But you must bear in mind that according to the case number and so forth, this is a 2008 case number.
Yes.
But I will certainly make efforts to do so.
But you agree that these are public documents? If the registrar of the High Court is approached, it will be easy to find these documents.
I would agree that they're public documents. I'm not sure if I can agree that they would be easy to find. I'm not sure what the processes are in KZN, but certainly my own experience, for instance, in the High Court in Johannesburg or in Pretoria, is that these things are not that easy to find. But theoretically, it ought to be easy,
Yes.
but practice dictates otherwise.
But of course, if the founding papers were found, as we have them now, it could have been, maybe the documents are in the MPA's office because they could obtain at least the founding papers, the answering papers that they consider to be relevant. So we could search and check if the NPA can be of help.
I'll certainly convey that to my client, Madam Chair.
Thank you.
Thank you, Madam Chair.
When will we know? Shouldn't your junior, in the meantime, go and ascertain whether such a document can be filed? And then by lunchtime, we should know. Your junior can find out from the NPA solo, so that we don't postpone this matter when the witness is still under cross-examination, because she finishes today. We will not call her back here to deal with a matter that we can easily dispose of today. If your junior can assist, we'll appreciate that. You may proceed. Proceed, Advocate Goitobi, and you can flag that part as regards the affidavit referred to by Major General Boison, which is supposed to be the affidavit of the MEC, second respondent in the High Court proceedings.
Thank you, Madam Chair. And then the second part then of the founding affidavit that I wish to refer you to are the specific instances of the murder that are mentioned in the founding.
Okay.
They start at page, under the heading, the killings, at page 58,
Okay.
at the bottom of that page.
Yes, I see.
And that's paragraph 28 That's the Ndimande killing.
Yes.
And Tembe, that is covered at paragraph 28 and 29.
Yes, I see it.
And then page 60 is the killing of Lindelane Buthelezi.
Yes.
And paragraph 32, the killing of Kopolot Nduli and Gosinathi Mthembu.
Yes.
Page 61, the killing of Mdum Kize.
Yes.
All of whom were in the hit list.
Yes.
Now, what is interesting is despite the allegation by General Boison
Yes.
that he was peripheral, he was unaware,
Yes.
he in fact says he was aware of each of these cases.
Yes.
You will see that from paragraph page 78,
Yes.
paragraph 31, that is where he deals with the killing of Ndimande and Tembe,
Yes.
and he repeats the police version that their lives were under threat.
Yes.
But nowhere does he say, I don't know what was happening, I was not present.
Yes.
Yes.
As a matter of fact, Commissioner Brown in his statement, somewhere he's saying that Major General Boison was the one reporting on the incidents,
Yes.
like showing intimate knowledge of the incidents.
Yes. Now, the same thing with the killing of Buthelezi at page 79, paragraph 33.
Yes.
Yes. He again does not say, I have no knowledge of the killing of Buthelezi. He, in fact, provides a justification for the killing,
Yes.
which is the same justification. We attempted to arrest, he resisted, we shot him.
Yes.
Yes. The same thing at page 20, paragraph 34, with the killing of Nduli and Mthembu.
Page 8.
Page 80, sorry,
Yes.
paragraph 34.
Yes.
Sorry. Yes. Now that's the same defense in the killing of Nduli and Mthembu.
Yes.
He does not say, what are you talking about? I had no knowledge. He, in fact, admits knowledge and
Yes.
gives a justification.
Yes.
Yes. The same thing with the killing of Mkize, which is paragraph 35.
Yes.
Yes. Now, yesterday, you spoke of this interesting word that comes from the racketeering, from the poker,
Yes.
the definition of racketeering, which talks about a pattern,
Yes.
the similarity of the methods that have been deployed.
Yes.
We've just taken 4 instances that he admits he was aware of,
Yes.
and he provides a justification. Can you just speak about this idea of a pattern?
It's about similar fact evidence.
Yes.
To say racketeering poker allows prosecutions of, in racketeering prosecutions, it allows for the admissibility of similar fact evidence.
Yes.
Where the similar type of illegal activities that are alleged to have been committed, for example, in the indictment,
Yes.
and may have happened prior to the dates that are covered in the indictment.
Yes.
But you look at the modus operandi and everything, they are similar.
Yes.
Those can be used as well.
Yes.
And it also shows and corroborates that those that are within the indictment really did happen, and shows the modus operandi that is being employed in the racketeering within the enterprise.
Yes. Now, in the case of Major General Boison,
Yes.
it's never clear to me what his defenses are. But if one of his defenses is lack of knowledge, can he actually sustain that defense in the light of his affidavit?
He can't. Even Mr. Danikas in his statement says it was in 2007, a year prior to the date covered in the indictment, which is May 2008. He says there were a lot of things happening. And during the murder of one Jabulani in Umlazi, they went there, he went there together, and he, according to Mr. Danikas, he had mentioned that this Jabulani will have a bullet planted in his head. And then they went to Umlazi. Indeed, Jabulani was killed. So he was aware. Even the Malvern one, where the two African males were in a garage, in a house in Malvern, he went there with Major General Boison, according to him, where he alleges that Major General Boison said they are not going to call the ambulance or the IPD. It was still called ICD.
ICD.
Yes. Until the second suspect also dies.
Yes.
Only after he dies, they will. So he's aware of all these things. And besides, if you are a manager, even though you were not even physically present at some of the incidents, if you see your members every time, whenever they have to go apprehend, apply legal processes, arrest suspects, every time suspects are killed, you don't investigate as a manager and say what is happening. Why are you not bringing any people to arrest and process legally through the criminal justice system? Why are all the people that you go out to arrest end up being dead? I mean, that's an obvious thing as well. Any manager is supposed and is expected to do that. Yes. Other than that, he was there at some scenes. He knows, yes.
Yes.
Thank you.
He made himself complicit
Yes.
in the conduct of his members.
Yes.
Now, it's the second time you've mentioned the Danikas allegation that Mr. Boison said that Mr. Jabulani would be found with a bullet in his head.
Yes.
According to the statement of Mr. Danikas, that actually took place in 2001, not 2007.
Oh, then it's my mistake.
Yes.
I thought it's 2007.
No, it's just to correct that. But but the event you described is exactly the same that he describes.
Oh,
Yes.
okay. Thank you.
All right, thank you. Now, I would like to move from the answering affidavit. I think we've established that
Yes.
he is lying, Mr. Boison, when he says he was unaware.
Yes.
He was aware and he provided a justification which, according to the NPA, is a false justification.
Yes.
Yes. Now, there were additional statements you referred to yesterday. There is one specifically that you mentioned, but you didn't go to the affidavit itself. It's at page 120.
Oh, yes.
Yes. Now, that is the affidavit of Ms. Thandeka Sokhulu.
Yes.
Yes, that is they refer to as the common law wife of Mr. Buthelezi.
Lindelani Buthelezi.
Mr.
Yes.
Lindelani Buthelezi.
Yes.
Now, just explain again what was the context in which you referred to this. My job now is just to show you that the affidavit exists. It's here.
I don't remember which docket it is in, but there were brothers. One of the brothers was killed, while the other brother was covered with a washing basin on his head.
Yes.
And then after being covered with a washing basin on his head, the allegations are that his brother was shot and killed.
Yes.
So I was relating this to what Ms. Thandeka Nompumelelo Sokhulu said in relation to her husband, Lindelani Buthelezi, during the night when he was killed by the police.
Yes.
She states that they threw a blanket over her head and then immediately they shot her husband.
Yes.
And immediately removed it after shooting him.
Yes.
So I was saying there's a similarity. It's also another pattern, modus operandi, but there's a similarity there as well as to how they operate.
Yes.
Even in another case where a son was killed in a room, the mother and the younger brother were just outside. Well, their heads were not covered, but the door was closed behind them. Yeah, like to remove people and then kill a person.
Yes. Well, the reason her affidavit is put here is because Mr. Lindelani Buthelezi is one of the persons that have been killed at the time the application is brought.
Yes.
As having been found in the hit list. And Mr. Mkiza is saying to the court, this is one of the persons who were killed.
Yes.
And I know the information from his wife, Ms. Sokhulu.
Yes.
Mr. Boison then says, this allegation must be struck out as hearsay because Ms. Sokolo's affidavit has not been attached. That is what he says in the answering affidavit. We just read that at paragraph 29.
That is not true.
Yes. Now, this is why then she then brings an affidavit in the reply to say, here is the affidavit. This is not hearsay, it happened.
Yes.
Yes. Now,
Before you proceed, I'd like to have a look at paragraph 29 that you're referring to.
yes.
The unsubstantiated hearsay point.
Yes, that ought to be struck out.
Now, the replying affidavit, I just need clarity here. The applicant is Bongani Elphas Mkhize. The replying affidavit, when you look at the tram lines, is the applicant's replying affidavit. The deponent is Tandeka Nompumelelo Sukulu.
Madam Chair, I think that is an error because the actual replying affidavit is earlier. I think I saw it at page 86 or something. 87, yes.
Yes, I think that looks correct.
Yes. And then all of these affidavits are just confirmatories to the reply.
Yes, let's go to the one that is correct, in respect of which you made the point concerning the alleged unsubstantiated hearsay point that was to be struck out.
Yes.
According to General Boison,
Yes.
and you then referred us to this affidavit.
Yes, at page
That
120.
seems to be the wrong one. The correct one is the one at page 87, you say.
Yes. Well, they are both correct, Madam Chair. The one at page 87 is the main reply. I can put it like that. And then the one at 120 is a confirmatory to that. It's just that the term line is incorrect. It should have said confirmatory affidavit. Or supporting affidavit. If you look at the one at 126, it's called supporting affidavit. Others are just called affidavit, probably the safest. Yes.
It is confusing, but I do understand.
Yes. Thank you, Madam Chair. Advocate Noko, can we then go to the affidavit of Ms. Sokulu? You remember that she is responding to the
Yes.
claim that it's unsubstantiated hearsay, it ought to be struck out. And you took a different issue with it, which is that why would you, as a senior policeman, oppose the admission of this affidavit, even if it was hearsay, bearing in mind the nature of the relief that a person is asking not to be killed, but to be taken to the police station?
Yes.
So you can park that idea and just focus on the merits of how she describes the killing of Mr. Butelis.
Yes.
Now- Yeah, sorry.
Oh, sorry.
No, carry on.
Okay. I was saying the description starts at paragraph 3. Should I read from there?
Yes.
Okay. It says, she says, there were approximately 20 policemen. When I emerged from the house, there were approximately 6 or 8 inside the house when they arrested my husband. When he disappeared from my sight, he was already subdued and under their effective control. There would thus have been no opportunity in respectful submission for him to have obtained or secured a weapon to threaten the lives of the policemen. I believe that the police had executed my husband on that night as they had behaved in very high-handed fashion. I too had been assaulted for no reason whatsoever and had a blanket thrown over my head.
So just wait there. Is this what you were talking about?
Yes. But she goes on
Yes.
about the blanket a little bit.
All right, carry on.
Yeah. She says, I verily believe that this was done, the throwing of the blanket, as she says, was done by the police in order to make double sure that I did not witness the unlawful actions. There is no other explanation why a blanket would be put over my head immediately prior to the sound of a gunshot and it being removed immediately thereafter.
It is correct, Counsel, that when you have regard to paragraph 5 at page 122, just mention it so that it helps us later. That paragraph 5 refers to General Boison's paragraph 33,
Yes.
where those allegations of unsubstantiated
Yes.
points are made. So, yes, she is then dealing with that aspect. I think the affidavit was then filed, among others, to deal with the specific part,
Yes.
as she refers to paragraph 33 of the fourth respondent's answering affidavit at page 122.
Yes.
Yes. It's quite a lengthy rebuttal,
Yeah.
but perhaps we should deal with it because
Okay.
because it's important to explain, if not to the panel, certainly to the public,
Yes.
why Major General Boison lied in his affidavit, according to Ms. Sokulu.
Yes.
She says, I wish to state categorically that the averments contained therein, that is in Major General Boison's affidavit, are false for the following reasons. What are those reasons?
From Roman figure 1, right?
Yes.
Yeah. When my husband left my view, I was taken to an adjoining room. He had already been under effective control of the police, who were approximately 6 to 8 in number at the time. Number 2, she says, he was unarmed and was not belligerent or showing any signs of aggression towards the police up until the time he disappeared from my view. 3, shortly after disappearing from my view, a blanket was placed over my head. A gunshot rang out. My husband was unarmed when he disappeared from my view. Number 4, the fourth respondent avers in his reply that my husband resisted arrest and attempted to shoot at the members of the South African Police Services who returned fire in self-defense. Briefly, he was killed in exchange of fire. Number 5, My husband had not resisted arrest and was effectively arrested when he disappeared from my view. Any suggestion by fourth respondent that he had resisted arrest is false. Besides, unless he was there, page 23 is blank.
No, it continues to
Or to
124.
24.
Yes.
Okay, besides, unless he was there, his averment that police acted in self-defense is hearsay and ought to be struck out by this honorable court. Number 6, further, the reading of the fourth respondent averments quoted above, it appears that my husband would have fired shots at the police with his firearm. I would like to reiterate that my husband was unarmed when he was taken out of the room. Number 7, at the moment of removing my husband from the bedroom, all that the police were asking him was, "What is your name?" There was thus no reason for taking him out of my view unless it was for the purpose of killing him in circumstances where there are no eyewitnesses. Number 8, it is also impossible that within this confined space that exchange firearm that fourth respondent refers to, that none of the members of the South African Police Services were indeed injured.
So this is an eyewitness that we would call an eyewitness. He was present there.
Yes.
Yes. And she is one of the witnesses you would have called if the matter had proceeded to trial.
Yes, and she's not the only eyewitness.
Yes.
In other dockets as well, there are eyewitnesses, like the examples that I gave where a mother and her son were closed out of a room and the other son of hers was shot inside there.
Yes.
But this one was an eyewitness in respect of the killing of Mr. Butelis.
Yes. Oh, yes.
And
it is
no
been-
other.
No other, yes. It's a separate docket, yes, Chair.
Yes. Okay. Thank you. But she also testifies that she herself was the subject of assault,
Yes, she says she was
which is
assaulted.
at paragraph 6,
Yes,
where she says there was no reason for the police to assault me
yes.
during the arrest of my husband, and their behavior in this regard is an objective indication of their high-handedness and disregard of fundamental human and constitutional rights.
Yes.
Now, so this is what you were talking about. If you go to page 125, you'll see the signature there, T.N. Sokulu.
Yes.
Yes.
Yeah, maybe just to assist proper recording also about, or to bring certainty on whether this is a what? Supporting affidavit
Supporting
or annexure.
affidavit, yes.
That will be found in page 98. Paragraph 3, you'll see the document is marked P, and line 3 says, contrary to the affidavit to the common law wife, annexed here to and marked P. So that's page 98.
Yes, I've got the page. I can't find the portion you
The
just read.
first paragraph, the third line.
Is that
Oh, yes,
paragraph
yes, yes.
22?
Paragraph
Add
22.
Paragraph
Yes,
23.
that is correct, yes.
Oh, yes. Thank you.
Okay.
Do you confirm that that is indeed the case?
Yes,
yes.
it is the position.
Sorry, I think I had overlooked that part. I suppose that answers the question that the chair had asked.
Yes.
Yes. Yes. You know, Madam Ramakhaga, once you've found the answer, everyone then finds it. My junior has now pointed out that at page 120, the P is actually at the top. so,
Yeah, it's marked P.
Yes.
That's why I say you connect that, then at least it's clear that it's an annex to.
Yes.
Thank
you.
Thank you very much, my sister, for assisting us.
All right, thank you. We finished the content of that affidavit, but this is
Yes.
what you were talking about in your evidence earlier yesterday.
Yes.
Yes. Now,
This
you
is indeed fine reading.
yes, it is. It is. It's reading with a tooth comb. Thank you. I want to move on to another category of evidence.
Okay.
We've dealt with this substantially now.
Okay.
You also mentioned ballistics,
Yes.
where you said you were also relying on ballistics.
Yes.
Yes. Now, I presumed that you had read those ballistics reports yourself.
Yes, I have.
Yes. Now, the first ballistics report that we have is at page 126.
Oh, yes.
And that is mentioned as supporting affidavit. If you turn the page to 127,
Yes.
it is signed by Jacobus Stale.
Yes.
I think we attempted to get hold of him. I think he currently lives overseas.
Oh,
Yes.
okay.
But at page 127, paragraph 3, he explains the context in which he got involved in the matter.
Yes.
On 18 September 2008, I was instructed by Tlapane attorneys, Durban, by telephonic consultation with Mr. Nathi Shozi, where he briefly gave me the background of a shooting incident which occurred along the N3 northbound, just past the Maryvale off-ramp.
Yes.
And then he explained the steps that he took to perform an examination over that incident.
Yeah.
Yes.
That's it.
Now, the actual report starts at page 131. Can you see that?
Yes.
Yes. And the assessment of the bodies that were found is at page 137.
Yes.
And that is where he deals with the body of Mr. Tembe.
Yes.
What did you say about 131? The report starts there,
The
actual report?
Yes, the actual report starts at page 131. The affidavit ends at 130, and then he attaches his report from 131. And then the examination of the injuries on the body starts at 137. That is Mr. Tembe.
Yes.
Yes.
Page?
Page 137.
Thank you.
Now, I want to just go to his conclusions that are at 138. There are 7 bullets of his conclusions, because
Yes.
it's something you mentioned in your evidence when you said the police claim that they were attacked by the passengers in the vehicle,
Yes.
but there is no evidence of any shots from inside the vehicle outside.
Yes.
Yes. Now, these are the preliminary conclusions he reached at that stage. We have another report which deals with the final conclusions.
Yes.
The first bullet says, on the right side of the vehicle, it appears that there could be at least 4 bullet entrance holes. 2 of these could have created injuries to the driver, and 1 could have created injury to the passenger in the left back seat. The trajectories indicate that the driver at least received a head wound and a right upper body wound.
Yes.
So what you have are bullets from outside into the vehicle, 4 of them.
Yes.
And those are the bullets that kill the driver
Yes.
because he's shot in the head.
Yes.
Yes. The second bullet, the injury to the back seat passenger was most likely a grazed wound due to the amount of tissue found and the absence of blood splatter on the door frame. Then the third one, At this stage, there is no indication that shots were fired through closed windows from inside to the outside.
Yes.
Yes, that's the point you made pertinently yesterday.
Yes.
Yes. It was indicated that the suspects were using assault rifles during the incident. It is peculiar that there were no pictures of these weapons on the scene. So,
Yes.
then he says, the two AK-47 cartridge cases found inside the vehicle and the absence of blood on the one found on the console raises questions of validity. Do you know what this is referring to?
The planted firearm.
But can you expand on that?
Isn't it? It was the claim by the police that they were being shot at.
Yes, by people
But-
carrying AK-47.
Yes. So now he's rebutting that to say the cartridges found were not compatible with the
Yes.
rifle. Yes.
Yes, exactly.
So it can be that they fired like
Yes.
yeah.
Yes. And that's what
So
it
the,
means.
the allegation that they were being shot at is not true. Yes.
Yes, absolutely. Yes. Now, the scrape marks and probable tire marks on the pants of the deceased seem to be consistent with the blood found from the back left tire. The blood drags marks on the scene, the abrasions on the deceased's body, and the broken right wrist indicate that the deceased was most probably fell out of the vehicle, breaking his wrist, and was dragged by the vehicle for some distance before becoming untangled. It appeared that the deceased thereafter received a number of gunshots while in this condition outside of the vehicle. If you actually can imagine what was happening, he's being dragged by the vehicle,
The cruelty.
yes, and then they shoot him outside.
Sure.
Yes. And by the way, their own report we read yesterday says he was actually running away when they shot him.
Yes.
Yes.
This is compatible with that.
Yes. Then it says, on the scene, after the police investigation, there were markings still visible, indicating that only 4 spent cartridge cases or exhibits were collected, which is also peculiar. Then it says, it is further peculiar that no state ballistic division member was involved in the reconstruction of this matter.
This is compatible with what the witness said, Mr. Danikas, that the scenes were being, murder scenes were being manipulated before the forensics are called and the IP and the like.
Yes. Now, this is the scene, the reason why this is so important. This is the actual scene that Major General Boison started, supervised, and then came to clean up.
Yes.
Yes. Now, Mr. Stale at the time, was he one of the experts that you were relying upon?
Yes. Mr. Jacoba Stale, Captain Mangena,
Yes.
those were the 2 prominent ones, yes.
Yes, we saw another report from, I think, Mr. Naidu.
Oh, yes, they could have been that as well, yeah?
But yes, that was in relation to the killing of the young boy.
KwaZindlovu.
KwaZindlovu.
Oh,
Yes.
yes.
But it was a joint report between Stale and Naidu.
Oh, yes.
Yes. Yes. Now, you see, the reason I've taken you through this, you see, what is puzzling is they first talk about the poker and say, well, poker has not been established. And then this is a straightforward case of murder.
Yes.
Yes. And in this panel, we have never been given with any justification why the murder case was not proceeded with.
If they feel that Section 21E and F have not been established, which is also not true. Yes, why not proceed with the murder then?
Yes.
Yeah.
And we know that Mr. Boison, Major General Boison, was initially charged with 2 counts of murder.
Yes.
Yes. Now, could I then move to the third feature of this? You remember that you spoke about witness statements.
Yes.
Now, that's apart from the expert witnesses. I'm
Yes.
talking now factual witnesses.
Non-expert witnesses.
Yeah, non-expert witnesses.
Yeah.
Advocate Nkabinde, if I understood you correctly, they say that it is murder, but it was never proceeded with.
Yes.
And then you again say Major General Boison was charged with murder.
Yes.
So are you suggesting that despite the fact that he was charged, that case was never proceeded with?
Yes, it is one of the cases that were withdrawn by the Director of Public Prosecutions, Madam Advocate Harrison.
That's what you mean?
That's what I mean.
Thank you.
And in this inquiry, we've never been given a justification why the murder case was withdrawn.
The 2 counts of murder.
The two counts of murder
As
were
part
withdrawn.
of the 5 predicate offences.
Yes.
Yes.
Yes. Now, I was going to move on, but I thought perhaps before I do that, it's just to put an end to that application that was brought by Mr. Shozi.
Yes.
So the outcome of that is at page 151.
I beg your pardon, Counsel. Back to that point of withdrawal. The withdrawal of the murder charges, was it at the same time with the withdrawal of the racketeering charges?
No, Chair, it was not. Advocate Batoyi withdrew the racketeering charges, the 2 counts. And then Advocate Elaine Harrison withdrew all the other offences.
The
including
predicate
the-
offenses?
Yeah, predicate offences and all other offences in respect of the other accused persons.
Do you perhaps, Counsel, have an indication or pages where such withdrawals were made? Because I'd like to look at the dates. First, the withdrawal of the racketeering charges by Advocate Batoyi, when precisely?
The one by Advocate Batoyi, is this the one? Is at SB 4229. And the date is the 16th of July 2019.
It will be at SB?
SB 4229.
SB 4.
Yes. Two to nine, yes, ma'am.
2 to 9.
Yes.
Yes, I see that. It's dated 16 July 2019.
Yes. So
Under the
if you,
signature of Advocate Batoyi.
Advocate Batoyi, yes. So if you, the heading is NDPP to withdraw racketeering charges in the matter of State versus Boison and others following a review process. And then in the 3rd paragraph, she then announces her decision. I've decided that the said authorizations are invalid and that the racketeering charges against all accused must be withdrawn. So she certainly took that decision on the 16th of July 2019. And she then later says, paragraph 4, in respect of the predicate offences as set out in the indictment, the panel concluded that there are various challenges with the evidence and the investigation in respect of each docket. In this regard, you are referred to paragraph C, D, and E of the report. You are accordingly requested to evaluate the evidence in each docket and decide whether to prosecute the individuals who may be implicated in these matters. I bring to your attention that the panel also found that there is insufficient evidence against General Boison in regard to the other charges preferred against him. Please take this into account in your evaluation of the evidence against him in respect of those predicate offences in which he is charged. As discussed with you, please contact with the next of kin of the deceased persons and explain the implications of my decision. It is important for them to know that the withdrawal of the racketeering charges does not mean that there will be no justice for the victims of the crimes. You will be considering whether there is sufficient evidence to charge any person for the other offences, including murder. So that's the instruction to the Director of Public Prosecutions. Madam Chair, I recall that I have seen in the context of the KwaZulu case correspondence about the withdrawal of other charges by the DPP of KZN. But I will ask my team to look for it.
Yes, we'll also ask our researcher to assist us to check that document. We'll also check, we'll ask our researcher to check the withdrawal of those predicate offences by Advocate Harrison,
Yes.
the document.
Thank you, Madam Chair.
If you find that document during the tea break, you can bring that aspect back.
Yes.
Then we can reflect on that
Yes. Thank you, Madam Chair.
so that it does not go through the cracks.
Yes. Thank you, Madam Chair. So, in terms of where that matter ended, that application by Mr. Bongani Mkhize,
Yes.
there are two documents that are relevant. The one is at page 149.
Yes.
That's the order for interim relief.
Yes.
Or
What page is that?
149. So there was an order given at page 150 on the 5th, on the 21st of October 2008,
Yes. Let's see it.
where the respondents were interdicted from killing, injuring, threatening, harassing, or in any way intimidating the applicant.
Yes.
So, which was the same order that Mr. Mkhize wanted.
Yes.
Yes. Now, that order returned to court on the 14th of November 2008 for final relief,
Yes.
which you see at page 151.
Yes.
Yes. And there was a
Yes.
consent order given.
Yes. I can see it.
Yes. It looks like the interim interdict was not by consent, it was contested.
Yes.
And then the final order was by consent.
Yes.
Yes. And the final order was that the respondents are interdicted from unlawfully killing, injuring, threatening, harassing, or in any way unlawfully intimidating the applicant.
Yes.
And then everything else was then discharged.
Yes.
Yes. So the point you were making yesterday, as I understood, is that despite the existence of these orders, Mr. Mkhize was in fact killed.
Yes.
The same applicant who obtained these orders.
Yes.
Yes.
If you may pause, Counsel. Toby, I'm going to request that we pause. I'm going to request that we pause and take an earlier tea break. We will reconvene at 11:25. You can hold on there. We will adjourn until 11:25. Yes, thank you. Ma'am, you are still under oath. You
Yes,
may
Chair.
proceed, Advocate Gauteng.
Thank you, Madam Chair. Advocate Noko, it's just something I forgot to ask you yesterday. Advocate Patoi has created the impression in this panel that when all of these events were taking place, she was out in The Hague and came back recently. And she's ignorant about what had transpired before. I can hear myself. So it's going. Somebody's recorded. Anyway. I mean, is this correct that because these are events of 2008 and 2009, is she telling the truth when she says she was not around?
No, she's not. According to my understanding, she's not, because I think she left the position of DPP when towards the end of 2009.
Yes.
From there.
Yes.
Yeah, and these events are from 2008, according to the indictment, yes.
Yes.
Yeah.
And for the most part of those events, they were sent to inquests that would have been that would have been overseen by her as the DPP.
As the DPP KZN then, yes.
Yes. So this narrative that she has peddled, that she's ignorant of this and that because she spent 10 years in The Hague is a false narrative.
I don't agree with it, yes.
Yes. All right. Now, before we broke, we were still dealing with the evidence of Mr. Stale.
Yes.
And I had intended to take you through to the factual statements to address the control element beyond the participation element.
Yes.
But
Sorry, you had just dealt with the interdictory reliefs at page 150
yes,
and the final relief at 151.
yes, Madam Chair.
Are you able to make sense as to when the Rule 9 was confirmed finally?
Yes, Madam Chair. We know that at page 151 that it was confirmed on the 14th of November 2008.
The 14th.
14th of November,
I
yes.
see the day stamp there is not very clear to me.
Oh, I see. In other words, the date on the order may be different to the actual date.
Oh, yeah. I see the date on the order. The day stamp is not clear, the
Yes,
registrar's
yes.
day stamp. But
Yes.
we can accept that it was confirmed on the 14th.
Yes, even the following page, actually, it's also not clear.
Yeah, it isn't. But let us accept for now the 14th of November 2008.
Yes. Thank you, Madam Chair. So the last of the witnesses who had dealt with was Mr. Stay, and the report he gave
Yes.
over the killing of Mr. Tembe.
Yes.
Yes. Now, my learned friend says that I should actually complete that section by going through to the final report that Mr. Stale gave,
Yes.
because we had looked at what he called the provisional report,
Preliminary, yes.
preliminary report, yes.
Yes.
And he did provide a final report, which you will see from page 247.
47. Yes.
And just to confirm, you had both of those reports at the time you were considering the matter.
Yes, I did.
Yes. Now, in the final report, that's now after he's read everything and he's giving this for the purposes of the court.
Yes.
Yes. And by the way, was Mr. Stale a witness of the prosecution?
Yes, he was a state witness.
All right, thank you. Now, in this one, he deals both with the body of Mr. Ndimande and the body of Mr. Tembe.
Yes.
Although in the first one, he dealt with only one body, which is the gentleman that was pulled out of the vehicle and then shot whilst he was outside.
Yes.
Now, where he deals with Mr. Ndimande is from page 257.
Yes, I see that.
Yes. Now, these are the observations of the killing of Mr. Ndimande under the heading Post-Mortem Report,
Yes.
which was conducted by Dr. Naidu, where the deceased is, it's spelled as Majoela, but we know this to be Magojela, Timson
Yes.
Ndimande.
Yes.
And then under item 1, it says an entry gunshot wound on the right side of the neck below the jaw with an accompanying exit on the left temporal area above the ear. There was also a bullet recovered from the skull. This trajectory is from the right to left and upward. Now, that's the right side of the neck.
And then going up.
Yes, and then it's also going up.
Yes.
Now, just on that description, how is it possible that these people were being attacked?
Exactly.
Attacked from the side?
It doesn't make sense.
And then they produce photographs there, which you will find, those photographs in that report are reproduced at page 278. Madam Chair, I have our attorney here just to show this blown up because they are not clear from the report itself.
Yes.
Yes, and I think there was a complaint last time that we had shown these images that depict violence without prior warning. So we are about to do that.
Complaints by who?
I don't know, it never came to me, but I was told that there were people that said we should have issued a warning that there will be graphic violence displayed.
Complaints from the evidence leading team? Or from the public?
Well, the person who has told me is Mr. Mtsweni.
Madam Chair, all I said was Tebega is going to fly sensitive pictures. Perhaps he should issue a warning so that members of the public out there can know that there will be graphic pictures shown. Because remember, the proceedings are being streamed, so there might be members of the public out there. As a matter of courtesy, not that is obliged.
I don't know, in the court proceedings, I've never heard of such. You publicize evidence. In any event, the evidence here is in the public eye. I'm not sure to what extent we can hide or warn anyone. I don't know how we do it. Do you have any suggestion as to how it should be done?
I'll think of a way, Madam Chair, and then I'll come back to the panel.
Speak louder.
I'll think of a way and then I'll come back to the panel.
Well, we are going to publicize it now.
All
He has
maybe
just
Mr.
indicated that he's going to flight it right now. So if you can maybe give a suggestion.
just by giving
wait
it
a
this-
minute, let me finish.
Okay,
Sir.
apologize.
If you can indicate how best we should deal with that, maybe we can consider.
Perhaps, Madam Chair, just to issue a warning to say there would be just a statement to say, well, warning to sensitive viewers that we are about to publish graphic photographs. Simple as that, so that at least whoever is watching knows that graphic photographs are going to be streamed. That's how they do it on the media, anyway.
This is not a media. This is
Then in that-
quasi-judicial proceedings.
In that way, Madam Chair, then I would not suggest. I would not persist with.
Suggesting?
Sorry, Madam Chair. I'm just told that they are not streamed. They're just for the inquiry. So I think it's fine. I thought they were streamed even on the media streams, but I'm told that it's just only inquiry. So I think it's fine. I thought they were streamed even on the media streams, but I'm told that it's just only in the chamber. So then there's no need for that, Madam Chair.
Now, I can assure my learned friend it's still images we will be playing. The videos are still coming. But today it's only still images.
If I may try to assist, whenever you are about to stream something that might be of a sensitive nature or shows gross violence, you may preface it with a statement that we are, whatever we're going to show now might be sensitive. And you leave it at that. People will just decide to watch or not to watch, but we can't hide stuff from the public. Thank you.
Thank you, Madam Palomer. We shall endeavor to do so. On the images, the better copies of those images, I think the one you have is black and white and it's also unclear, will be
Yes.
at page 278.
Yes, that's right. Yes. You can see that.
And photograph 22.
Yes.
Yes. Now,
21.
and that is what is referred to at paragraph 1. See photographs below. And then the next one is at 279. Yes.
Yes.
Yes. Now, if you just stay at 279, you will see there where the blood flows from the neck, but at the back of the neck.
Yes.
Yes. I will come back later to see the trajectory of the bullet. But you
Yes.
can see there where the blood is flowing. And you can see where his hands are.
Yes.
And you cannot see anything there about a machine gun.
Or anything like that.
Yes.
Are
Now,
you referring to photo 23?
photo 23, yes, Madam Chair, sorry. Photograph 23. Yes. Now, the reason why that introduction is necessary is what the expert says after in paragraph 2. He says, an entrance wound behind the head with an accompanying exit wound on the left neck. So entrance behind the head.
Yes.
This trajectory is from back to front and downward.
Yes.
Yes. The bullet damage to the driver's headrest is consistent direction and angle with the wound track of gunshot wound above. And then it continues. There were a further 2 entry gunshot wounds on the front right shoulder and 3 exit wounds over the right shoulder at the back. This trajectory is from front to back and slightly downwards. So it's shot on the shoulder.
Yes.
Yes. Now, this then continues under the heading post-mortem report
Yes. I see
of
that.
that one is describing Thokozani Tembe. What we know about Demande is that he's shot literally here.
Yes.
Yes. And when they describe Tembe, they say the deceased was Sibusiso Thokozani Tembe. There are no post-mortem photographs to assist in determining the general wound ballistics. However, it appears from the described wounding, as well as the abrasions on his arms, shoulders, and left back, as accompanied to the photographs, that the deceased was dragged by the vehicle. He was found on the scene behind the vehicle. The doctor noted the wounding. See photographs below. Remember the narrative of General Boison and his people in the affidavit
Yes.
He said so himself in the affidavit, was that the police retaliated after they were being shot.
Yes.
Now, we know that they shot this man from the back. They shot Mr. Demand from the back.
Yes.
Yes. And then on Mr. Tembe, we know that he was running away when they shot him.
Yes.
Yes. And then the way it's described under item 1, there are photographs there. Those photographs, I think, are at 276.
Yes.
So
Yes.
photo 17 and 18.
Yes.
Yes. And this is how they are described by the expert. Entry gunshot wound below the left ear.
Yes.
Page 276, you said?
Page 276, photo number 17
17.
and 18. Yes, those are the
Yes.
clearer ones.
Yes.
Clearer ones. Now, when it says below the left ear, that is almost at the back of the head.
It is.
Yes. With an accompanying large and gaping exit wound below the right ear. So the bullet came from the left and they exited on the right ear, but it was all in the back of the head.
Yes.
Yes.
Sorry, don't leave us behind. Where is the narrative?
It is paragraph 1 under the photographs. If you go to page 258,
258.
yes, and paragraph 1, they've got the two pictures which are not clear on the narrative but are clearer on the photo album.
Yes. Thank you.
Yes, thank you. So what we were dealing with is the description of the entry gunshot wound below the left ear, which then exits on the right ear. That's why there's a, what they call a gaping exit.
Yes.
Now there was a large exit.
Exit wounds, yes.
Yes. Now that's what those pictures show.
Yeah.
Yes. And then 2, entry gunshot wound to the inside of the left nipple with an accompanying exit wound to the outside of the left nipple. Now you remember how this was described was that in the first provisional report was that they shot him while he was lying down.
Yes.
Yes. Which explains then the shot on the nipple. Because he
Yes.
was lying down at that point.
Yes.
Yes. This wound is from right to left and upward. See the photographs above. So that is photograph 18
Yes.
And on,
at page 276.
yes, on photo 18, around the nipple there, I see abrasions.
Yes.
Is it where the entry bullet went? You see that darkness there
Yes.
around the nipple?
Yes, Madam Chair. Yes. Yes, according to this, that would be correct according to this because there is a heading, abrasions.
Where? Oh, yeah.
Yes, at 258 after paragraph 2.
Yes, I see that. Thank you.
Yes. So it says there are multiple abrasions noted to the following areas: left temporal area. So that's exactly where the chairperson is referring to. Below the left eye and over the right nostril. Left shoulder at page 259. Left elbow, forearm, left hand, over the right side of the back, right elbow, a compound fracture on the right wrist. Then the expert then concludes, these are consistent with the photographs taken at the scene. These abrasions and the fracture also confirm that the deceased was dragged for a considerable distance behind the vehicle. And we've seen this evidence before.
Yes.
Yes. Then, if you then skip a page and go to page 260,
Yes.
under the heading of the scene investigation,
Yes, I see it.
yes, they start by saying on 22 September 2008, that must have been about a week after the shooting, because these gentlemen were killed on the 16th of September.
16 September, yes.
I visited the scene plus minus a kilometer after the Maryvale off-ramp on the northbound N3 highway.
Yes.
The green marks left by the police as well as the blood were still visible on the road surface. I took photographs and measurements of the scene. The blood drag mark on the road surface was 27 meters long. 27 meters. That's the
Yes.
blood drag. That shows the distance that this gentleman was dragged, that Mr. Tembe.
Yes.
Yes. He was dragged for 27 meters.
Meters, yes.
I examined the scene for any further exhibits and walked at least a kilometer back and could not locate any cartridge cases. I only retrieved the sunglasses of the deceased back passenger. And then there are two photographs there of the scene. And those, I'm told, we do not have the color versions from the photo album.
Okay.
And then, under the scene photographs supplied by the ICD at page 261, he says, I received a CD containing 98 photographs depicting the scene, as well as the vehicle examination at the police pond yard in Pietermaritzburg. It is clear from the photographs, especially where exhibits were found, like the firearms and cartridge cases, that the scene was not in its original condition, i.e., it was not an undisturbed scene. The firearms were placed behind and to the side of the vehicle. See the photographs below. Now that picture you will see at page 274 at photo 13.
Yes.
So let's just deal with the first part where he says they interfered with the crime scene.
Yes.
Now, you remember that this is where Mr. Boison was personally present.
Yes.
Yes. And is this why he was charged with defeating the ends of justice?
Yes.
Yes.
That is the reason.
Yes. Now, it then says, the narrative below the picture, it appears that the cartridge cases found inside the vehicle were only photographs the next day when the vehicle examination took place at the police pond yard. In other words, not photographs on the 16th, but photographed on the 17th.
Eh. Yes.
Yes. It was alleged that the occupants of the vehicle fired shots at the police from the open left rear back door while traveling. And then this is the point you were making earlier.
Yes.
There were no AK-47 cartridge cases indicated, found, or photographs on the roadway which could support this version.
Yes.
Because they found an AK and then they said they were shooting us with the AK. But miraculously, there are no AK cartridges.
Cartridges, exactly.
The only cartridge cases indicated are located in the outside vicinity of the vehicle, in this stationary position, and in the inside of the vehicle.
Yes.
Yes. Now, then, he continues, some photographs depict the deceased in PM 183 11 9 2008 Magojela Timson Dimade, seated in the driver's seat, slumped over to the passenger's side. There is blood splatter visible in the steering wheel, the dashboard, as well as the passenger's seat. There was further blood pooling visible in the passenger's seat. The blood splatter observed on the passenger's seat is consistent with the deceased having slumped over with blood dripping from the head wounds, whereby the body completely relaxed. Thereupon, the body impacted on the blood pooling on the chair. See photographs below.
Yes.
So what they're saying is that this person was sitting, was shot and then slumped.
Yes.
This is not someone in active combat.
Yes.
And those pictures we looked at earlier, the first one is 279, photograph 23. That's him slumping over after being shot on the back of the head.
Yes.
And then the other one is at 286.
That's for the blood spot.
Yes, that's for the blood spatter. So that's 286. I think it's photo 37.
Oh, yes.
Page 2,
286.
286.
Photo 37. And then it continues on the crimes that were committed in the crime scene.
Yes.
Says that is now the narrative below the pictures at 262.
Yes.
The deceased in PM 183 120 2008, Sibusiso Thokozani Tembe, was found lying in a position behind the vehicle with a pistol at his feet.
Yes.
There is blood splatter visible on the firearm in the vicinity of the slide and grip. There are further scrape marks visible on the side, and the hammer is in the backward position, which indicates the firearm might be loaded.
Yes.
It is further unclear where this firearm was originally located and in what position it was found. And then
Yes.
they show the picture.
Yes.
And that picture in black and white is sort of clear enough, but we don't have the color copy. It's not in the docket.
Yes.
Now, this is again evidence of the interference with the crime scene by planting a gun.
Yes. That's the defeating the ends of justice as
Yes.
one of the predicate offenses.
Yes. And then it continues. There are photographs indicating various cartridge cases on top of the blood inside the vehicle. However, the original position of these cartridge cases is unknown. That again means they have moved around the cartridge cases.
Yes.
Yes. It appears that there are 5 fired cartridge cases inside the vehicle, 7.62 and 39 millimeter. See photographs below. Which just aggravates the interference, because after they've done this, they go inside and then they shoot.
Yes.
Yes, the same policemen, they just randomly shoot a firearm and put it inside.
Yes.
Yes. And then those pictures you will find at page 285. Those 4 pictures there.
Yes.
Photograph 35 and 36.
Yes, I see
So
that.
2 of the 4, sorry. 285, 35 and 36.
Yes.
This K2 that you are depicting here at 285. I see 1 cartridge there.
Yes. Which is the first one on the left at 262. Yes. Two at two. Just go back to 2. Yes.
At page 262,
Yes,
I
it's
see...
K1 and K2 actually.
Yes.
Yes.
K1?
K1 is the one on the left at
Yes.
page 262.
And
Now,
K2?
K2 appears to be the one at the bottom, in the middle.
Yes.
Yes. And Mr. Ramukhale says the other two are difficult to match. I have to accept his... I have to accept his bona fides.
So you only have the K1 and K2?
I think,
In
Madam
your-
Chair, we have all of them, but the problem is that they are so dark. It's so...
Even on the screen?
Yes, but we have the clear pictures on the screen. I think what he's struggling with is matching them because he can't actually see those dark pictures so that he can compare them clearer with the because they could also be K5 and K4. They could also be, yes, they could be K4, they could be K5, which are the closest when you look at them. K4 and K5 is at 287.
Yes.
But I think all of us are reluctant to commit because we are just unsure.
Yes, I see cartridges there, photo 39,
Yes.
K5,
And K4.
the top of the arrow there,
Yes.
and at the bottom, there's another cartridge there.
Yes, yes,
Yes, thank you.
yes. Thank you. Now,
And as regards the narration by Mr. Stein, where are we as regards this depictions?
yes, the narrative there is at 262 in the last paragraphs. Yes. Where he says the cartridges have been put on top of the blood splatter. That's the first thing he makes.
Yes.
Yes. And then he says, but I cannot work out what was the original position of these cartridges. So that's what he says. These photographs indicating various cartridge cases on top of the blood inside the vehicle. However, the original position of these cartridge cases is unknown.
Yes.
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 Actually, the clearest instance is actually K1 itself, which is at photo 35, page 285. So that you can see that it's a bullet superimposed on a blood splatter.
Also K5.
K5, yes, K5. Photo 41. Yes, 41 at page 288.
Yes.
Yes.
Thank you, Advocate Noko. I think that
Thank you.
observation was well made. And then he then comes to the conclusion of all of this. We have done with the images. Thank you. He then comes to the conclusion at page 264.
Yes.
Now, this is on Mr. Magojel.
Yes.
Yes. The inside bullets says, based on the information available to me at this time, it is my opinion that the deceased was Magojela Timson Demande. The deceased was the driver of the vehicle. There was an entrance wound and associated exit wound on the top right shoulder, of which the trajectory most likely continued through the right side of the neck, below the jaw, with an accompanying exit wound on the left temporal area above the ear. There was also a bullet recovered from the skull. This trajectory is from right to left and upward. So it's actually shot on the side, which is totally consistent with someone driving a vehicle
And being shot, yes. from
or
the
sitting in a vehicle, even if they're not
Yes.
driving.
Yes.
And then, which is probably the most clear instance of an ambush attack, is the last one.
Yes.
There was an entrance wound behind the head with an accompanying exit wound on the left neck. So they shot him from the back.
Yes.
They were truly ambushing him.
Yes.
This bullet trajectory most likely followed a path through the back right rear passenger window and through the headrest, resulting in the above wounding. So that explains why we have those 4 bullets shot from the window outside into the vehicle.
Yes.
Yes. We've dealt with the 3rd, 4th, and 5th bullet under the section of the narrative.
Yes.
Now, the same or similar narrative appears in relation to Mr. Tembe. If you turn the page to 65.
Yes.
Yes. And the first bullet, which is the 2nd paragraph, says there was an entry gunshot wound from below the left ear with an accompanying large and gaping exit below the right ear. So that it's shot in the ear from
Yes.
back to back on the side.
Yes.
Yes. There was an entry gunshot wound to the inside of the left nipple with an accompanying exit wound to the outside of the left nipple. This wound is from right to left and upward and could be associated with the impact damage to the door frame on the left back passenger window. Tissue was clearly visible in the vicinity of this defect, which also indicates that there was a passenger seated in the left back. So again, this is another side
Yes.
shooting.
Yes.
And then he says all the windows of this vehicle were closed during the shooting incident. There is no indication that shots were fired through closed windows from the inside to the outside.
Yes.
You emphasized this yesterday.
Yes.
Yes. There could be at least 4 bullet entrance holes on the right side of the vehicle. 2 of these could have created injuries to the driver, and 1 could have created injury to the passenger in the left back seat. And then he continues, the AK-47 cartridge cases found inside the vehicle on top of the blood and in the absence of blood spatter raises questions regarding their original position.
Yes.
Yes. There are further clear indications that the crime scene was not properly documented and photographs to indicate the exact position of firearms and exhibits in their original position.
Yes.
Then he deals directly with this allegation of exchange of gunfire. He says it was alleged that there was an exchange of gunfire between the occupants of the vehicle and the police while traveling. However, no cartridge cases were indicated, found, or photographs on the roadway which could support this version. The only cartridge cases indicated are located in the outside vicinity of the vehicle, in its stationary position, and inside the vehicle. That is how he then concludes.
Yes.
Now, you know, I asked the person who ensured the withdrawal of these charges, Advocate Batoi, whether she was familiar with the work of Mr. Jacoba Stay. She
Yes.
said she wasn't. But you, as the people who took the decisions to prosecute, had actually read these reports.
Yes.
Yes. And had recommended, inter alia, based on them, that a criminal prosecution was indicated.
Yes.
Now, that's in relation to Mr. Ndimande and the direct participation of Mr. Boison,
Yes.
contrary to his consistent narrative that he came to the scene afterwards.
Yes.
Yes. Could I then take you from this? There are many of these examples. If we actually did this, it would take us 30 days
There are.
to go through all of this.
Yes.
But there is one you mentioned yesterday repeatedly, which was the gentleman that was killed inside the dustbin.
The Mbonambi,
Yes, that was Mr. Mbonambi.
Devon North Docket. Yes.
Yes, that's the Durban North Docket.
Yes.
Now, I'm not going to go through that docket, but I just want to briefly go through those images just for you to confirm with us that
Yes.
they are consistent with your recollection.
Okay.
That should be file 2. If you can go to file 2. What page is this? Just want the one with the accident. Oh, yes, actually, the map. Yeah. All right, so I need you to have file 2 and file 3 in front of you.
Before you proceed, still at the conclusion of Mr. Steyn at 266, what do you make of the fact that the expert says it is surprising that no ballistic examiner was called to a scene such as this in order to perform a ballistic reconstruction? Who ought to have called a ballistic examiner?
The police should have called the ballistic experts, the forensic experts, and everyone, Chair. And also then it shows it consistent with what Mr. Danica says, that the crime scenes were being manipulated before the forensics are called. So when the forensics get called, the scene is already mixed up, then they'll come up with something that is not correct, accurate, because the scene was manipulated. But it is the police, the first ones at the scene, they shouldn't touch anything. They're supposed to call the forensic experts.
In other words, it would have been a futile exercise even if the ballistic examiner would have been called, because there was, according to you, a tampering with the scene.
Yes.
You understand what I'm saying?
Yes, unless maybe a thorough examination was done, like how Mr. Jacob Stale did, not just taking pictures. Because I think Mr. Stale was referring to pictures of the scene as it originally was.
Yes, but my point is, we know now that a ballistic examiner was not called to the scene.
Yes.
And you are saying, ordinarily, the examiner should be called immediately before or after the shooting, before any tampering.
Yes.
And I'm asking you, it follows that it would have been a futile exercise to call an examiner, a ballistic examiner, post the tampering.
Exactly, yes, Chair. It would have been.
Yes, I would like the witness to have file 2 and 3 at the same time. So if we are on file 3, the report of Mr. Stale is at 227 of file 3.
I have it.
You've got it, okay. Yes. Then
At which page?
227.
227.
That's where the report starts. Yes. Now,
Yes.
this report deals with the killing of Mr. Mbonambi.
Yes.
Yes. Now, Mr. Mbonambi is the gentleman that you said was running away from the police, tried to hide inside a rubbish bin,
Yes.
and then they chased him and shot him while in a crouching position inside a rubbish bin.
Yes.
Yes.
Doesn't it also deal with Mr. Mkhize?
Yes, it's also the report covers both Mr. Mbonambi and Mr. Mkhize. It is. Yes, that's correct. In fact, that's yes. Under the introduction, on the 6th of July 2011, I was instructed by Mr. Ahmad from the attorney firm Ahmad's Attorneys Devon to attend a medical legal post-mortem and thereafter visit the scene where the deceased Mr. B.S. Mbonambi Mkhize was shot and killed. Now, these were the people killed on the same day, 3 people killed on the same day.
Yes.
Yes. What I would like you to do is to go to page 233,
Okay.
just to look at the description, and I'll compare
Yes.
that with the actual images we have of that scene, which
Okay.
I have no
Yes.
doubt you considered at the time,
Yes.
because that's why, even without the pictures, yesterday you could rattle off these facts from
Yes.
memory.
Yes, because
Yes.
I read this.
Yes. Now, at page 233 of file 3,
Yes.
there is a summary of the wounds that were sustained by the deceased.
Okay.
And that is the last paragraph under the heading wounding.
Yes, I can see it.
Yes. It says the deceased sustained the following major wounds.
That is Mr. Mbonambi.
Mr. Mbonambi, yes. A high-velocity, unstable bullet gunshot wound to the right side head with a fracture of the skull. This wound is located behind the right ear. So what we see here is also a shot from the back.
Yes.
Yes. Now, unlike what we saw in the previous case, at page 234, they say there is no associated exit wound with this entry wound. So they shot him, but it was lodged inside.
Yes.
Yes. A deformed copper jacket bullet of 5.56 caliber projectile, R4 and R5 type rifle, was retrieved from this wound. This wound is from right to left and upward. Now, I had read somewhere that the R4 and R5 bullets explode inside the body of the object.
Yes.
They spin and explode.
Yes. I had so too.
Yes. Do you confirm that?
Yes.
Yes.
Too.
Now, the reason why it's important to know the nature of the gun that was used
Yes.
is to know whether it is true or false that there was an intention to apprehend or an intention to kill.
Yes.
Yes. Now, if you use a 5.56 caliber projectile, which spins and explodes inside the body of the victim, I mean, what is the most sensible interpretation of that?
To kill.
Yes.
It's to kill.
Is to kill, yes. Now that nature of that, the R5 bullet it appears in the report by Mr. Stale in
Yes.
relation to KwaZulu. They killed a 16-year-old boy using an R5 bullet.
Yes.
Yes.
Who was asleep?
Yes. Then in paragraph 2, they say a high velocity, unstable bullet gunshot wound through the neck. The trajectory was from right to the left.
Yes.
This wound is consistent with a 5.56 type projectile wound fired from an R4, R5 type rifle.
Yes.
A high velocity, unstable bullet gunshot wound through the right shoulder. This trajectory is downward. So in other words, it's from the top downwards,
Yes.
shooting him on the shoulder,
Yes.
and is consistent with a 5.56 type projectile wound from an R4, R5 type vehicle. A deformed copper jacket projectile was removed from the wound track of a 5.56 caliber.
Yes.
4. A high velocity unstable bullet gunshot wound on the right upper front chest wall. This trajectory is from right to left and is consistent with a 5.56 type projectile wound fired from an R4, R5 type rifle. Copper jacket bullet fragments were found consistent with a 5.56 caliber. Basically, it's the same conclusion at 5 and 6.
Yes.
Now, this is what was found. These bullets are shot from top to bottom, but
Yes.
they are also lodged inside his body,
Yes.
and there is no exit for them.
Yes.
Now, if we then do a comparison of the actual scene of the crime, we will find that the photos appear from page 435 of file 2.
Okay. Yes.
If the is that him? Page 1, page. Okay, let's start with these on the crime scene. So let's just start with those that were found on the scene of the crime at page 435. Now, page 435, photo 5.
Yes.
Yes, that is the picture of these large bullets from
Yes.
these machine guns.
Yes.
Yes.
Okay.
But photo number 6
Yes.
is actually how Mr. Mbonambi was found.
Yes.
Yes. Now, I'm not an expert, you are not an expert, but just as an ordinary person, I mean,
Yes.
how is this person posing any danger to anyone?
I also don't understand. He seems to be hiding inside a dustbin.
Yes. Then if you turn the page to 436,
Yes.
photo number 9.
Yes.
Now here you can see clearer
Yes.
what they meant when they said he was shot from the back of the right ear,
Yes.
because here you can see his right ear
Yes.
and the bullet, the entry part of the bullet.
And the blood spatter onto the on the left side
Yes,
to show the exit.
yes. And it seems to me that could have been somebody from the top of the rubbish bin, not from the
Yes.
side or anything, because
Yes. Okay.
it's actually lodged.
exit.
Yes,
Oh, lodge, no exit. Yes.
yes.
Can see it.
Now, the same with photo number 10,
Yes.
because remember that they found an entry on the right shoulder
Yes.
and another entry on the back of the right ear.
Yes.
Yes, which is clearer now in photo number 10.
Yes.
Yes. If you then turn the page to 437, photo number 11.
11. Yes.
Yes.
You can see it.
So you can see the danger of this bullet. Those are the bullets that spin and explode.
Yes.
Now you can see the explosion here,
Yes.
that it actually ruptures the flesh.
If it's the victim, yes.
Yes. There is one that is still necessary to see clearer, but these were the pictures at the scene of the crime.
Yes.
But he was then taken to a mortuary where his body was cleaned, but his wounds are more visible there. So if I can take you to those. So starting at 423. Photo number 5.
Yes.
Yeah. So this one is clearer. What Mr. Stale was talking about where they
Yes.
found, and then he said these were coming from top to the bottom, and you can see the one behind the right ear, and the one
Yes.
on the shoulder, and the last one on the chest.
Yes.
Yes. But you can also see that they've ruptured the flesh of the
Yes.
body as well.
Yes.
Yes. And that's photo 5 and photo 6.
Yes.
Yes. And you turn the page to photo 7.
Yes.
I use 423, 423, and then 424. And 425, 426, 427. Yes. Yes. And then there is another one at 433. Page photo 24 and 25. That's also come in
Yes.
from the back.
Yes. You can see it.
Now, I mean, we've seen the expert description,
Yes.
and we've seen the photographs that back up the expert description.
Yes.
We've seen also, just from a common sense point of view, a man crouching inside a rubbish bin.
Yes.
And we've seen the bullets most probably having been shot from top to bottom.
Yes.
And we've seen the nature of the bullets that were being used.
Yes.
Yes. I mean, can there be any doubt that this is consistent with an intentional murder?
There's no doubt.
Now, this case of Mr. Mbonambi, what is curious here is there is a version given by the police. The person who actually killed him was, I think, Inspector Lee. And his affidavit is not file 2. Oh yes, you're right. His affidavit is at file 3, page 166, 186. So he was shot. The person who shot him is Raymond Lee. And his affidavit is at page 186. Yes. Who says that he is part of the provincial organized crime unit. But
Please wait a second. Yes, thank you.
yes, thank you, Madam Chair. But if you look at that paragraph, he says, I'm from the provincial organized crime unit, which may appear to exclude Cato Manu. But if you look at the second paragraph,
Yes.
on Monday, 4 July 2011, I was on duty. I had been asked to assist the Cato Manu members
Yes.
as Warrant Officer Mostert had received information a possible robbery was to take place in the Durban North area by suspects driving a gold Hyundai iX35 motor vehicle with registration ZHC 767 GP. So this was a Cato Manu operation.
It was. Yes.
Now, this is how he describes and justifies the killing of Mr. Mbonambi.
Yes.
It is at page 187,
Yes.
paragraph 5.
Yes.
He says it was approximately an hour later when members of the public began informing us that they had seen a man running through a property in Norfolk Road. Children in the complex also visited us and informed us that they had seen him climb over a fence near Unit 1. They described him as wearing the same clothes that Warrant Officer Martin had seen him in. Warrant Officer Martin and I began to search the area. We then entered the complex's bin area, and I began opening the bins to search for the suspect, as I felt that they were big enough for a grown man to hide in. Warrant Officer Martin was standing behind me and giving me cover. The bin area was very small, and the bins were in an L shape. This is now the moment where he shot him. The next moment, I saw the last bin on my right begin to open. I immediately turned towards the bin. I realized to my horror I was looking at a human face, and next to it was a pistol which was pointing at me. I shouted and jumped backwards into Warrant Officer Martin, now in mortal fear of my life and unable to retreat further. I opened fire with my R5 assault rifle in the direction of the bin, which immediately closed again. Now, this scene is truly from a movie. According to him, the bin opens, a man stands up with a gun,
Yes.
and then the man closes the bin with a gun again.
Yes.
And we've seen the pictures. There is not even a stone inside the bin.
Yes.
And then he continues, I opened fire with my R5 assault rifle in the direction of the bin, which immediately closed again. Without taking my eyes from the bin, I explained to Warrant Officer Martin what had happened. While covering the bin and Warrant Officer Martin then approached the bin and opened the lid. He informed me that the suspect had been wounded and was inside the bin. Then he immediately called radio control. Now, this is the best version of the killers.
Yes.
I suggest to you that this is the most improbable, made-up story. It would have been obvious to any trained prosecutor that the police are lying.
Yes. I agree.
Yes. And there is no one else who was there who did the shooting other than Mr. Lee, Raymond Lee.
Yes.
This is their only version of how the shooting happened.
Yes.
The other person is Inspector Martin, who was watching the shooting.
Yes.
Now, I'm not a criminal lawyer, but you have to take this version and put it against all the other evidence that exists to show that this was an execution, and then decide whether or not a prima facie case has not been made. Isn't that the way it should work?
Yes, and there are eyewitnesses who saw this incident taking place, who say they saw the police. One of the witnesses said to the police, Mr. Mbonambi had hidden in the bin because they thought the police were chasing after a real criminal, only to see the police just shooting at him
Yes.
inside the dustbin.
Yes. Well, we will not go through the eyewitnesses, but the eyewitness statement is at page 189 of that same bundle.
Yes.
What page is that?
189, Madam Chair, of Wandile Mbonambi. Now, this was a child. He was 12 years at the time.
Yes.
Yeah. And he described what he saw.
Yes.
That the police chased after and killed his father.
Yes.
It's a statement at 189.
189, yes. And it's made by Wandile Mbonambi. Yes. I am a male teenager, 12 years old, at grade 6 learner at Virginia Primary School. And he described in detail what he saw.
Yes.
Cops came chasing, looking for his father.
Yes.
His father ran, of course, because the police were looking for him. But then they shot and killed him in
Yes.
cold blood.
Yes.
And that is also supported by the Independent Complaints Directorate. There's a statement from the ICD at page 194.
Yes.
And another statement from them at page 198.
Yes.
And then the expert reports. So, I mean, this is what you were trying to come towards when you kept on saying, but why are they killing people in a rubbish bin?
Yes.
And why is the murder charge withdrawn in those circumstances?
Yes.
Now, as I said earlier, we can go over and over this. We will find all of these same patterns.
Yes.
And there are 28 people that they killed,
Yes.
but the pattern is the same.
Same pattern. Yes.
Now, I want to move to another topic. We dealt with Mr. Boison's awareness from
Yes.
looking at the affidavits that he submitted and his own admissions
Yes.
and the police statements, etc.
Yes.
But I want to look at the control element, that for a racketeering case under F,
Yes.
you have to also
2-1-F.
show 21F, you also have to show control.
Management.
Yes, if you're showing him,
Yes.
if you're charging him
Yes.
as a manager.
Yes.
We've shown him as a participant.
Yes.
Now I want to just look at the evidence of him as a manager.
Yes.
Advocate Toby, the statement by the ICD at 194. When was it taken? Well, I see at 197 the commissioning.
No, it doesn't have a date, no.
Yes, the commissioning doesn't show the date, time and place. Shouldn't there have been a day stamp there, at least?
Yes, Madam Chair, there should have been. But it's not.
At least as regards the one that appears at
194.
199 up to 201, there is a time given there and the date, although there's no date stamp.
Yes.
What should we make of that?
Madam Chair, I am not sure if it would meet the requirements of the is it 1972 regulations on commissioning if it does not have a date and a place where it was commissioned. It might affect technically its admissibility. But if there is a requirement that it should be commissioned.
If we are to accept that under the POCA provisions, when situations in respect of which hearsay would be admitted and in a court of law dealing with a normal criminal matter, hearsay evidence will not be admitted.
Yes.
In an inquiry of this nature, could this kind of a deposition,
Yes.
despite the fact that the commissioning seemed to have been erroneous,
Yes.
or rather not complete, could we take that into consideration?
We would say yes, Madam Chair, that there is no requirement that the statement even needs to be commissioned. But if there was an attempt to commission it, but that attempt was defective, it would still be admissible under the POCA provisions.
But perhaps these are matters that could be left for argument.
Indeed.
And I see your junior is sharing some wisdom with you.
No, it turns out that he's missed the plot this time.
Yes, I'm just raising it so that at the later stage, both you and the evidence leading team at an appropriate moment, when you make submissions, you can assist us in that regard.
Yes. Thank you. We shall.
You
do
remember that also during the time when Advocate Batoyi was testifying in chief, we were referred to certain statements, some of which were not properly commissioned.
Yes.
And the evidence leading team placed those statements before us, and you may just as well together prepare helpful submissions in this regard.
Thank you, Madam Chair.
Chair, may I please say something? I see the witness we're talking about is Anele Mpanza, where the commissioning, but then there's another statement of the same person that seems to be better commissioned because there's the designation, the name of the Commissioner of Oath, there's address, work address of the Commissioner of Oath, there's date, time, and place.
Yes.
Okay.
Kind of, it seems to be a replica.
Yeah.
The second one at 198
Yes.
seemed to be a replica of the one at 194.
Yes.
So you are rescuing Advocate Gaitovi's team.
Well,
We
it
will
is-
look closely, but from the look of things, it seems to be a replication of that statement that appears at 194.
Madam Chair, I was just not sure if it was a replica, and so I didn't want. That's what Mr. Ramukhalo was telling me. But the problem I had was that I wasn't sure if it is a replication. I actually doubted. If you just look at the last page, at page 197, and you compare that with page 201,
Yes.
yes, so you see there that these are different statements. Now, I have not done word-for-word analysis. I actually doubt if they are the same, because if you look at, again, 196, and you look at paragraph 7, and compare that with page 200. At page 200, there's a paragraph 8. There's no paragraph 8 at page 196. So I didn't want to take this and simply accept what you were telling us, that this is something to be argued later.
The second one seemed to have gone further.
Yes.
From paragraph 8.
Yes.
But everything up to paragraph 7 seems to be the same.
That's possible.
You are correct that there is an addition of paragraph 8 in the subsequent statement. The
Yes.
one where the deposition, there's a date on the commission in there. But again, maybe you can focus on the subsequent statement, because all that appears in the previous one is incorporated in the subsequent one where there is a date.
Yes. Yes, thank you, Madam Chair. It
On
could
the
be that.
cursory reading of the first one, you'll see that everything seemed to appear up to paragraph 7.
Yes.
Yes.
Thank you, Madam Chair.
You will look at that, we will also look, and then you'll decide what you make of this point.
Yes. Thank you, Madam Chair. Yes. Advocate Noko, I wanted to move the discussion forward to look at not the participation, but the control or the management.
Yes.
And to do that by reference to the evidence of witnesses. We've already looked at control through the statements of the SAPS,
Yes.
where they themselves say this is the man that is in control of the unit,
Yes.
even though he's been placed at the provincial office.
Yes.
Now, that is entirely consistent with a number of witness statements. Let's start with from page. So, are you back with file 1? Do you have file 1?
Yes.
Yes. Now, there are 3 affidavits of Mr. Ayer.
Yes.
The first one is at 169 up until 172. The second one is 173 up until 178.
Yes.
And then the last one is 179 up until 183.
Yes, I have that.
During the testimony of Advocate Batoi, these statements were referred to, am I correct?
Yes, they were referred to.
And they were subsequently marked as exhibits.
Yes.
Do you remember at the end of the evidence in chief, the NPA team was to give us a collated list of exhibits. Just want to make sure that we're not going to do a repeat of those annexures and marking them again as exhibits. It will confuse the record.
Yes, Madam Chair.
Let me ascertain from my researcher. or
So
even
these statements.
the MPA team, am I correct, Madam Advocate Halley? I see you're nodding your head. Maybe you can just bring that roving mic so that she can speak to this point. I do remember that a document was presented to us at the end of the evidence in chief. It was at our instance as we guided as to how those documents should be prepared. Advocate Halley, your junior assisted us in that regard. Am I missing the point then?
Thank you, Madam Chair. Yes, they were dealt with. They were actually dealt with in her supplementary affidavit. So it's going to be, it is actually an attachment to her affidavit. But it is referred to in the list of exhibits.
And that list of exhibits, which I remember you presented it.
That's correct.
We should all be having those exhibits, and you should pick from those exhibits and do the numbering properly.
That's correct. That's correct, Madam Chair.
Advocate Goitobi Ramukhali, you should confer with her to make sure that you pick from where she ended. You can refer to the document because we already have it. We will name it here in our notes because we do have that list. Somebody should produce it to us. Our researchers over there, you can assist us.
Yes.
We will not name it as an exhibit because it's already named, but I do remember that these three documents appeared somewhere and were named.
Yes.
For progress, I think you can proceed as long as you remember that.
Yes. Well, Mr. Ramukhale, I suppose for the benefit of the NPA team, tells me that these statements are not in the list of exhibits.
They are not in the list.
Yes.
But they appear in the third volume.
Yes, they are in Advocate Batoi's affidavit as
Yes.
annexures, but they've
As
not
annexures.
been included yet. I'm sure they will include them in due course.
Please.
Madam Chair, as I said, yes, they are part of Advocate Batoi's supplementary affidavit. They are attached to her affidavit. So that which was not on record already is in the list of exhibits and with reference numbers where in the record that the document will be found. So the statements of Colonel Aya are attached to the affidavit of Advocate Batoi.
Was evidence tendered during her evidence in chief about those statements?
That's correct, yes. Yes. Those statements were part of the NJs, NJ 1, 2, 3, 4, and 5. And because there was a mishap, some of the pages were missing, some of the last pages were missing. That had to be corrected. In correcting such, a supplementary was then filed.
My question is, was evidence tendered by Advocate Batoi in relation to those statements by Colonel Aya?
Madam Chair, the evidence in relation to those statements was that those statements were attached by Advocate Jiba to an affidavit that she filed in the first Boison review application. So that was the evidence that was around this particular statement.
I thought that the fact that they were referred to and they were marked, if my recollection is correct, and what needed to follow was for you to then collate them and name them as exhibits in that list. I don't remember where we ended with the exhibit numbering.
I understand, Madam Chair. The understanding was that on her affidavit, it stands as it is with its annexures. And then everything that she referred to in her affidavit, which is not attached as an annexure, goes to the list of exhibits. So the list of exhibits will contain documents that she spoke to in her evidence, refers to in her affidavit, in some of the letters that were exchanged between her office and the minister's office and Advocate Chauke. Some of those annexures weren't part of her affidavit. So all those are referred to in the list of exhibits. But all that her affidavit came with are attached to her respective affidavits. The founding, the first, and the second supplementary affidavit.
Yes, that's not my understanding of how we directed. And someone has to correct me. My understanding was that we will have a list of exhibits, the annexures as attached to the papers will then be named sequentially as exhibit 1, 2, 3. You'll say annexure what is exhibit what, so that we don't find ourselves repeating as we may be repeating now. That's why I was raising the point that if those annexures were named, we talked about naming of those documents as exhibits, so that we have at least a list of those annexures now named as exhibits. Then we could go back in our list and say, this very document, Colonel Ayer's statements, 3 statements, were they named? That's where I come from.
Thank you, Madam Chair. I will upload them on
Do you
the
remember
list.
that?
Yes, I remember. I just had it, I think, the other way. But I will. It shouldn't be difficult. I will put all her annexures on the list.
Yes, thank you.
Thank you.
Yeah, I think just to clarify the issue, because this comes from the question by my sister, Justice Nkabinde, about whether Advocate Batohi testified about the statements. And it is clear, it appears from my record that the statements of Bull Ayer were read into the record on the 26th day of November. So which means those documents are there, they have been read, they are part of the evidence. The only thing then that is outstanding, now that you understand the directive, is just to add them onto what you already have. Thank you.
Thank you, my sister. Advocate Kogachobi, you can then refer to those documents, and we will pick the numbering from the list that Advocate Lekhetu is going to give us.
Thank you, Madam Chair. You are at file 1, page 169, correct?
Yes.
Now, this is the first statement by Colonel Ayer.
Yes.
This is, if you look at the date at page 171, it's dated the 3rd of August 2012.
Yes, I can see that.
Yes. Now, he says, on Thursday, the 2nd of August 2012, I met with Brigadier Mukone at my office, 9th floor, Savamos building.
It looks like a Mukweda.
Mukwena?
It looks like it, yes.
Yes. I was requested to submit a statement regarding the structure of the organized crime since December 2006 on the appointment as Unit Commander Organized Crime. Now, you will recall the theory that the NPA was working from is that the Ketumano unit operated as an enterprise for the purposes of Section 2 of POCA.
Yes.
Yes. Now, he is then asked to explain what is the structure, who is in command of that enterprise.
It's a he.
Or he is being asked. Okay,
Yes.
thank you. Now, just explain this to me. In the definition of an enterprise under POCA, is it a requirement that the enterprise must be an unlawful enterprise?
No,
Yes.
it doesn't have to be, as long as it is used as an enterprise.
Yes, exactly.
Yes.
And do you know that Mr. de Kock, Advocate de Kock,
Yes.
actually concluded that it is required that an enterprise must be an unlawful enterprise?
No,
Yes.
he was not correct in that.
Yes. So which actually means that Advocate Batoi relied on a report which contained an egregious error of law.
But POGA legislation is clear on what an enterprise is.
Yes. But it does mean that Advocate Batoi did not satisfy herself about the basic terms of POCA.
That's what it means, yes.
Yes. Now, this is what he then explains. Shortly thereafter, in January 2007, the Serious and Violent Crimes Unit closed the National Commissioner. Only 14 members from Serious and Violent Crimes were restructured into the Durban Organized Crime. In terms of organized crime mandate, the Serious and Violent Crime Investigation became the mandate organized crime. I was informed that the then director, J.W. Boison, was appointed as Provincial Commander of Organized Crime in KZN in February 2007. So from February 2007, he is supposed
Yes.
to leave Ketumano
Yes.
and go to the province.
Provincial office,
Yes.
yes.
All 4 unit commanders of organized crime had to report to the then director, Boison, directly in KZN. Then Director Boison was accountable to Provincial Head of Detective Services, Assistant Commissioner P.T. Brown, who retired in 2011.
Yes.
So Commissioner Brown is the direct boss of Major General Boison.
Yes.
As a unit commander of Durban Organized Crime, holding the rank of Senior Superintendent, I had 3 superintendents who had to report to me and were accountable to me as section commanders, namely Superintendent T.T. Dube, Support Administration, Superintendent W. Olivier, in charge of Serious and Violent Crime Section, the other Superintendent, Gat Leroux, in charge of Drug, Firearms, Vehicles, and Gold Diamond. Between these 2 section commanders, W.C. Olivier and Gat Leroux, all operations conducted under their supervision. Under the command of Superintendent Olivier, he had 3 captains accountable to him, and then he names them. You can ignore the rest of that. And then he says in the last paragraph, shortly thereafter, problems started to surface with Serious and Violent Crime Section. After an inspection conducted by then Director Nchinga of the Hawks of the National Organized Crime Office, in her inspection report, she wanted to know why the unit was split into 2. Her instructions was that all members must report to one office, namely 136 Victoria Embankment, where my offices had been. I tried to explain to Superintendent Olivier, who was not too happy regarding the decision. I am fully aware that Superintendent Olivier was close to the then Director, J.W. Boison. I told Superintendent Olivier, a measure has taken place on the instruction of National Office. Superintendent Olivier changed his attitude towards me. Now you will recall that Superintendent Olivier is meant to report to Colonel Ayer.
Yes.
Yes. But he says, I told him he must report to me, but he's not happy with that.
Yes.
Yes. I noticed that Superintendent Oliver reports all incidents directly to the then director, J.W. Boison.
Yes.
So he's skipping the actual line of command to Mr. Boison.
Yes.
I was merely informed afterwards or long after any shooting incident had taken place in his section. Almost every week, the Cato Manor offices were visited by the then director, J.W. Boison, without me being informed. So even though he is at province,
Yes.
he is constantly in the office and people reporting directly to him.
At Cato Manor.
At Cato
yes.
Manor, sorry, yes.
Yes.
Now, I kept telling him to register all operations or raids on the caste system, but nothing of that nature, of that happened. Now, I found this a very peculiar part when I was reading this statement. Apart from this issue that they were reporting to Mr. Boison,
Yes.
to Major General Boison, why were they not registering cases on the caste system? They conduct an operation, but they don't register on the caste system.
Yes.
Can you explain what, could be the explanation behind the police doing a raid or an operation and then not registering it on the caste system?
It is clear from the evidence of witnesses that they were just seeking people, apprehending them, shooting and killing them.
Yes.
Because if they were conducting proper legal processes, they would have been recorded in all the records of the police as the system requires. So it shows.
But then he says, I told Mr. Oliver to report, but he refused.
Yes.
Then let us see what he says was the basis for the refusal.
Yes.
He says, he started frustrating me as unit commander. It is clear that Superintendent Oliver was acting on own accord. He was forming his own unit at Ketumano and had the backing of then director J.W. Boison, who constantly visited the Ketumano office. So
Yes.
it's clear that what he is saying is, well, instead of reporting to me, they report to Mr. Boison.
Yes.
I give him an instruction, he ignores it because he's got the support of Mr. Boison.
Yes.
Then he continues, the trouble started to surface when I noticed strange faces and members alleging to be members of Durban Organized Crime Unit at Ketumano offices. Some of these members and reservists claimed to be members of the Durban Organized Crime Unit. I had no indication who these members, e.g. Captain Eva, reported to Ketumano without any written document. Members like Sergeant Padayache, Warrant Officer Ganes, many moved within the unit without my permission. These members started to behave as they felt and became hostile towards me. Information was that all these members are only accountable to the then director Boison. I had no support from the director Boison. So again, this is the same thing. People who are not even part of the serious and violent crime unit
Yes.
are coming into the unit. He is not informed, but they report to Mr. Boison.
Yes, even Mr. Danikas, in his statement, he started by saying he was a reservist at the Katomana unit. He was recruited by Major General Boison, who made sure he gets into the Katomana unit and gave him all the documentation, blue lights for the car, all the equipment that he needed to be a member, and he worked with them, but through Major General Boison.
Yes. Now, then it continues, when I eventually informed them we cannot run two offices, and I served those members with notices to move them from Cato Manor offices, that is when the aggression and anger surfaced. All of them ran to the then director, J.W. Boison, office at Province. Then Director Boison came down on me heavily. He walked into my office on that day, raised his voice, and stated that the decision regarding Cato Manor is in his hands, and I should not interfere anymore, and he left for the airport. So, quite apart from what he was witnessing, he was told directly
Yes.
by Major General Boison
Yes.
that Cato Manor is under my control.
Yes. That's what he's saying.
Yes. It was very clear that I was not in command of the Cato Manor offices. I was shocked that since that day, Superintendent Oliver operated on his own. They did not report to me. I was victimized. My son was attacked in school. That doesn't seem to be relevant, and he's talking about the cell phone. That is also not relevant. If you go to the following page,
Yes.
he again continues on this line of the control, that the de facto control of the unit was under Mr. Boison.
Yes.
The section under Lieutenant Colonel Olivier started to call themselves the Cato Minor Organized Crime Unit. State resources, emails, and financial were sent directly to the then director, J.W. Boison. Although I was the unit commander, I was not in control of them. I
Yes.
reported this to very senior officers. That did not help.
Yes.
So, I mean, you couldn't get clearer where a man says, I'm just here on paper, but all of these people work with Mr. Boison. He's in control of them.
Yes.
Yes. The more I tried to act on the issue, the more I was victimized by the now Major General J.W. Boison. He tried everything possible to suspend me and misused the departmental procedure to target me. He tried everything in his power to move me out of the unit. He recommended that I must be moved out from my post so that he could put someone he wants to run the unit. Then you skip two paragraphs and start with the paragraph that starts with "to this very day." Can you see that?
Yes, I can see.
And then skip everything there to the line that says "those members," and that will be 1, 2, 3, 4, 5, 6 from the bottom. Those members.
Okay, let's start from the top.
So where this says, it says "to this very day." Can you see that?
Yes,
that
I can
paragraph?
see that. Yes.
Yes, if you then count 1, 2, 3, 4, 5, 6, 7, the eighth line from the top, the sentence starts with "those members."
That line begins with the minister's
Oh, the minister's office,
then
yes.
full stop.
Yes.
Okay, you say the eighth one.
Yeah.
1, 2, 3, 4, 5, 6, 7, 8. No, it starts with major. Oh, the minister. Then it's the seventh one.
Yes,
Okay. Yes, I can.
Just
see
read that.
Okay. The minister's office. Those members at Ketomena office acted under command of Major General Boison all the time. All media reports on all incidents came from Major General Boison and not me. All graphic pictures of shooting on crime scenes was put in by journalist called Mr. Anil Singh, a friend of Boison, of Daily Sun newspaper. I do not know how this journalist got to those crime scenes and where he obtained those pictures.
Yes. Now, we've seen when on a fair reading of the statement of Colonel
Yes.
Ayer,
Yes.
what he is saying is that on paper I am the head, but the person in control or managing this unit is Major
Yes.
General Boison.
Yes.
Now, was this one of the witnesses you were supposed to call?
Yes, he's one of the state witnesses, yes.
Yes. Because, I mean, it's also unclear why on earth would Major General Boison be answering media queries of Cato Minor when he's the provincial head?
Yes, and goes to report, well, anyway, he reports to Commissioner Brown. He had to report to him, but my point is he reported everything showing intimate knowledge of the unit.
You know, the report by Mr. de Kock, Advocate de Kock,
Yes.
criticizes Colonel Ayer, not by the content of what he said,
Yes.
but they rely on the criticism by Advocate Nazir Kasim in the disciplinary hearing against Major General Boison, that he is obsessed, these are the direct words, obsessed with his own self-importance. I mean, just hearing those words, are they fair when you just read what he's actually talking about?
They are not even relevant
Yes,
to each other.
yes.
Yeah.
Now, you know, this part we've been reading, which is, this is the person at Cato Minor, and he is telling the world that the person running the show here is Mr. Boison.
Yes.
If Cato Minor is an enterprise that's committing unlawful acts, it's under the control of Major General Boison.
Yes. That's
Would
what
that
they say.
satisfy the requirement in 21F of the poker legislation?
Completely for managing the enterprise, yes.
Yes. Now, this goes further. We have somebody below Mr. Boison. Now, let's look at the person above Mr. Boison. What did they say about who is in control of the Cato Minor unit?
Commissioner Brown.
Yes, Commissioner Brown. You will find his statement at page 214 of the same bundle. That's the first statement. He gave two statements.
Yes.
And then the second statement is at 219, which is called the supplementary statement.
Yes, I can see it.
Give me a second, please.
Thank you, Madam Chair. Oh, yes, perfect. Where is the judgment?
The criticism that you mentioned earlier, made by the disciplinary hearing chairperson, I suppose,
Yes.
does it, or is it reflected in the disciplinary findings of Chairperson Kasim SC?
Yes, it is, Madam Chair. I think we have it, if I'm not mistaken.
It is on that bundle, page
On
186.
page 186, yes.
At SEC.
Is it in file 1? Yes. In file 1, page 186.
Find the criticism in this report that you say that the COP team seemed to have relied on when they criticized Colonel Aya.
At paragraph 44, page 200.
Yes.
In fact, we could have a look at that. Thank you, Madam Chair. Because
we can read it into the record.
yes,
It is telling.
yes. It says in paragraph 44, I found Colonel Ayer to be a dismal witness in material respects. He is obsessed by the notion of his own importance. That's what I remembered. Those words struck me.
Yes.
And his entire testimony was permeated by his political acceptability and self-importance. I find him not to be the kind of professional policeman one would expect holding the rank he holds. His tenor of evidence, as I have indicated above, is one in which he emphasizes his own importance but lacking in conduct justifying any usefulness. I think those in charge of the SAPS ought to carefully consider Colonel Ayer's continuous role in the police force. In his quest for acceptance and self-importance, he was determined to tarnish Boison's reputation and dignitas, irrespective of the cost to the overall interest of the police force. If in fact the employer party actually believed that it could establish a case against the employee based on the evidence of Colonel Ayer, this was a serious error of judgment and was still a strong indication that the employer sought to create a case where one did not exist. Then this is where it continues. Colonel Ayer's affidavit, we know the only affidavit that was before him was the affidavit we've just read.
Yes.
And other documentary communications he relies on is punctuated by inventive and occasionally pure hatred for Boison. Now, I mean, is there anything there in that affidavit that shows any hatred towards Mr. Boison?
I did not see that.
Yes. I mean, and is there anything that shows the desire on the part of Colonel Ayer to be politically acceptable?
No.
Yes. So this entire ruling is just gratuitous insults against a witness who's actually doing his best that he could.
It seems so.
Yes. And then he says he is obsessed by the notion that there is a vendetta to have him killed to the extent that he is paranoid. I found no substance in this speculative realm of make-believe. Osander, a Greek philosopher, observed that envy is the pain of mind of which successful persons cause to their neighbors. This, I think, is the case with Colonel Eyre. You know, what I really found puzzling with this, there is not a single reference, not one reference to the actual evidence
Yes.
that Colonel Eyre gave about the fact that Major General Boison was controlling the unit. What has happened is that the writer of this document has degenerated himself into a personal attack against a witness.
It seems so.
Now, the strange thing is that these gratuitous statements that have no basis at all
Yes.
made their way into the report of the 4 panelists, which was then relied upon by Advocate Batohi. No one actually reading the underlying statement from Colonel Eyre.
Yes.
And even yesterday, there was an attempt to undermine Colonel Eyre's statements, even in this case, by the evidence leaders, without any reading of the actual statement.
Yes. And its essence.
Yes.
Let us then go to the Cox report and see how these remarks found their way in that report.
Just want to see the paragraph. So, in the Tikok report is paragraph 109 in the Advocate Tikok report. Sorry, it starts at, it's SB 168, SB 3 168. I think it starts with paragraph 107.
I know that you gave us those bundles yesterday. We have them in our files, but it was easy to look at that document that you handed up.
Yes. The first reference I could pick up is at paragraph 107. But the part I was talking about is paragraph 109 at page 35 of the report. So paragraph 109, do you have it, Advocate Nogo?
Yes, I do. On
Yes.
page 35.
Yes.
Yes.
Now, this is where, you know, the power of a lie, you know, lies and repetition.
Yes.
This is where they just repeat the findings of Advocate Kasim without examining the underlying material.
Yes.
Yes. They say in paragraph 109, Eyre's credibility was questioned and he was discredited by Advocate Kasim SC in the Boison internal disciplinary hearing. Advocate Nazir Kasim SC, the chairperson of the disciplinary hearing against Boison, described Colonel Eyre, who testified before him, as a dismal witness in material respects, is obsessed by the notion of his own importance, and his entire testimony was permeated by his political acceptability and self-importance. And then you would expect, as a dispassionate reader, that they would explain why those allegations are correct.
Yes.
You then turn over the page, you don't find even an attempt to read the statement and then to say, well, is it gratuitous or is it fair to insult a witness like this?
Yes.
But look at what they say. They just say, in our view, a witness should be both credible and reliable. In our view, no reliance should be placed on the statements of Colonel Ayer. But you ask yourself why?
Yeah,
You don't find a reason.
clearly.
Now,
Council, it's after 1:30.
indeed.
If you can guide us how long you're going to take with this witness still. We had proposed that we'll have lunch around this time, and are you still going to be long?
Look, it depends, Madam Chair, on whether my junior is insistent on one theme that I said I should not pursue. But if he is not insistent, I should be 30 minutes.
You are the boss.
So we're still debating on whether a certain theme should be pursued or left for a future witness. But if I win them over on that, I should be 30 minutes.
But let me check with all of you. First with my sisters. Yes, thank you. Advocate Toby, I am guided by my sisters, and I think you'll find it also acceptable that we pause to have lunch until 2:15. When we reconvene, you'll utilize your 30 minutes. Mr. Ramkhali is not going to extend it to an hour. And thereafter, the evidence leading team will seize the moment to re-examine.
Thank you.
Let's have a lunch break until, say, 2:15, and you will utilize your 30 minutes, and the evidence leading team will use whatever time. And thereafter, we can adjourn then to have a meeting that was proposed in the morning. If you are still minded to have the meeting, you owe us a report about the issues that we raised yesterday, Advocate Kosana. Yes, thank you. Until 2:15, we adjourn. Good afternoon, everyone. Good afternoon, Menoko.
Good afternoon, Chair.
Good afternoon, Dr. Chauke. Advocate Nkabinde, you may proceed.
Thank you, Madam Chair. Advocate Noko, I wanted to move to the second aspect of control or management. We dealt with the evidence of people below Mr. Boison, particularly by reference to Colonel Aya, and we went through to show that the criticism against him was an unfounded criticism because its original source was Mr. Kasim SC's decision, which itself has no foundation.
Yes.
Then I said I wanted to look at the people above Colonel Aya to see what do they say about the structure of Ketuman.
Yes.
Yes. And we looked at the two affidavits of Commissioner Brown. The first one you can ignore for the current purpose. It will become relevant later.
Okay.
But the second one is the relevant one directly, page 219 of file 1.
Yes, I have it.
Yes. Now, he is explaining the structure of how Ketumano operated. And we know that formally, General Boison is supposed to be in the province, and Colonel Aya is supposed to be in charge.
Yes.
But
Yes.
substantively, Colonel Aya says General Boison is running the show.
Yes.
Now, that's the context in which he now needs to clarify what's actually happening as the boss of General Boison.
Yes.
In paragraph 1, he says, the poor relationship between Major General Boison, the members of the Ketumano Organized Crime Office, and Colonel Aya as the commander had a direct impact on the management style of Major General Boison. He adopted a hands-on approach in respect of matters involving this unit. So,
Yes.
I mean, his own boss says he was hands-on on the unit.
Yes.
Yes. Colonel Aya's perceived lack of knowledge on serious and violent crime matters and the culture of serious and violent crime units led to a breakdown in their communication. This meant that Major General Boison was more operationally involved in matters at this unit other than at other units in the province. He also used the services of Colonel Zikali at provincial level to coordinate the activities of the unit. He would visit the Ketumano weekly on a Tuesday for the grid meeting. His management style ensured that the unit continued to function optimally. Now, we know Colonel Aya says every week General Boison was there.
Yes.
But we also now know that even according to Commissioner Brown, in relation to this unit,
Yes.
General Boison was hands-on, visited weekly, and was operationally involved.
Yes.
Yes. Now then, it continues. Remember that Lieutenant Colonel Olivier, who reported to Colonel Aya,
Yes.
actually did not take instructions from Colonel Aya,
But
but from General Boison.
Yes.
So even that is dealt with at paragraph 2.
Yes.
The relationship between Major General Boison and Lieutenant Colonel Olivier was one of complete trust and respect. They had both served at Amanzimtoti during their formative years in the police. They also worked very closely when the project office was stationed in Rosberg. This contributed to easy communication between him and Major General Boison.
Yes.
Now, what this means is that, again, Colonel Aya is completely correct that Lieutenant Colonel Olivier
Yes.
refused to take instructions from me, and instead he took instructions from Major General Boison.
Yes.
And Commissioner Brown is explaining that it's because they have a prior working relationship and they
Yes.
trust each other.
Yes.
And they are criticizing Colonel Aya for not having sufficient knowledge of the unit.
Yes.
Yes. Then, paragraph 3, the accepted protocol for conducting organized crime investigations or operations outside the unit's boundary would be to inform the unit commander of the unit where the investigation or operation would be conducted. The same would apply to investigations or operations conducted outside the province when the provincial commander of the other province or the local unit commander would be informed. This was not necessarily followed, you see. So they say this is the rule,
Yes.
but we don't follow the rule.
Yes.
When information was at hand, which indicated that secrecy was essential due to local police involvement with the suspect sought. For trips outside the province, prior approval would be required on the trip itinerary from the unit commander, provincial commander, and the provincial head of detectives. So what they're saying here is this. When Colonel Aya says, I was not informed of operations,
Yes.
and I asked them to open the system on the CAS system, open the cases on the CAS system, they say, no. Sometimes the information required secrecy, so we wouldn't inform you.
So, yes.
Yes. And then, paragraph 4, when a death in custody as a result of police action occurred, the member responsible was required to have the matter reported to the local area duty officer, who would dispatch a duty officer to the scene and ensure that the independent complaints directorate member on call was informed to enable their attendance at the scene. This required ICD form and the shooting incident report had to be completed, and the duty officer would report the matter to the provincial nodal point for inclusion in the daily crime report. During the daily morning crime meeting, the core management of the province would be presented with a crime report by crime intelligence. When organized crime members were involved, now this is K2
Yes.
Major General Boison would confirm the contents of the shooting incident report
Yes.
and provide additional information which had been provided to him or from his own personal observation at the scene.
That's what I meant when I said
Yes.
he reported to his commander, Commissioner Brown,
Yes.
showing intimate knowledge
Yes.
of the scenes of crime. That
Yes.
way, yes.
So on 2 occasions, they set out what the rule ought to be,
Yes.
which they say was not followed at K2.
Yes.
So both about the flow of information before operations are undertaken
Yes.
and the recordal of the information after operations.
Yes.
Yes. And then, depending on the decision of the ICD official, a case would be registered for investigation either by themselves or the local detective, with them monitoring the investigation. Progress in the investigation would be reported to area and provincial level. But the point here is really this.
Yes.
Even according to Commissioner Brown, the person who was operationally involved at K2 as the manager was Major General Boison.
Yes.
Colonel Aya was excluded, didn't get the information. Even the reports were drafted from the personal knowledge of Major General Boison.
Yes.
There is something in the first statement that is somewhat curious. You remember that this entire case, which ended up becoming the K2 issue,
Yes.
was allegedly about taxi violence.
Yes.
At least in part about taxi violence. There are other instances about ATM bombings.
Yes.
But the majority of it was taxi violence.
Taxi violence, yes.
And it was expected that the persons responsible would deal with the issue of taxi violence, and if there are allegations of misconduct by the police, they would be investigated at a senior level.
Yes.
In other words, if the police at K2 misconduct themselves, is it not reasonable to expect that the person who would investigate them would be their boss or their provincial boss, General Boison?
It is.
Yes. And you can see now from Commissioner Brown that he is in fact part and parcel of that team. So how can he now have the ability to consider their misconduct?
I'm not sure about that, but I'm noting it.
Yes. Because that probably explains why, because he was part and parcel of the team, there was impunity at K2.
Oh, yes. I get the point, yes.
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 You see, in the first statement of Commissioner Brown, which is at page 214, there is a paragraph at page 217 paragraph 12.
Yes, I see that.
Yeah, the fourth paragraph, the fourth sub-paragraph of paragraph 12.
Okay. I see it.
So this is what they say. A provincial team of detectives stationed at Umhlanga Rocks was formed to deal specifically with the cases arising from the conflict between KwaMaphumulo and Stenga Taxi Associations. Okay?
Yes.
The investigation in these cases was monitored by Lieutenant Colonel van Rensburg and Major General Boison.
Yes.
You see. Now, this strikes me because your evidence is Major General Boison and the Cato Mano team
Yeah.
received cash bribes
Yes.
from the members of the Stenga Taxi Association.
Yes. That's what the witnesses are saying. Yes.
Yes. Yes, according to the witnesses.
Yes.
But that would have been the case of the NPA had it been allowed to continue with the trial.
Exactly.
Yes. But the conflict here is that Major General Boison is the very same person assigned by the province to oversee the investigations into taxi violence.
Yes.
But instead of overseeing the investigations into taxi violence, he has abused his position, accepted money, and carried out unlawful killings of one association to the benefit of another.
It seems so.
Yes. Who is this Lieutenant Colonel van Rensburg?
If I'm not mistaken, he could be one of the accused in the Catamene.
Yes,
His name rings a bell. He might be one of those.
yes. So you have an instance of the same people that have been told to monitor the situation
Yes.
are in fact inflaming it, doing the opposite.
It seems so, yes.
Now, having gone through this affidavit, both affidavits of Colonel Ayer and the affidavit of Commissioner Brown,
Yes.
what is your summary in relation to the requirement in subsection F, 2 subsection 1 subsection F, of control or management of the enterprise?
He was in full control and management of the enterprise. And this is what we had in front of us when we applied for a certificate for racketeering authorization. It's part of those that we had.
Yes. Now, you remember that I mentioned to you that there is a fundamental misconception in the de Kock report
Yes.
because it requires the enterprise
Yes.
necessarily to have been an unlawful enterprise.
Yes.
Now, I want to take you to those paragraphs. Of the de Kock report. The first one is paragraph 190, subparagraph 1. SB3, page 201.
Subparagraph?
190, subparagraph 190.1, sorry.
Oh, yes, I have it. Proceed.
Thank you, Madam Chair. Paragraph 190.1 is crucial because the panel has now done its job. It's explaining,
Yes.
in conclusion,
Yes.
why your indictment was legally wrong.
Yes.
They give the first reason, paragraph 190.1.
Yeah.
If you look at 190, it says, it is clear from our discussion that the prosecution will not succeed in proving the racketeering offences for the following reasons. Reason one, there is no evidence to establish the existence of an unlawful enterprise separately from the existence of a pattern of racketeering activity.
Hawker talks about enterprise, not
Yes.
legal or illegal.
Yes. In fact, there is a judgment of the Supreme Court of Appeal on this very point. We ask for leave to hand it up. It's called S versus Asen, delivered on the 17th of September 2008. Do you have the judgment?
Yes, I have it here.
Yes. Now, you've just said to us, Porker speaks about the enterprise.
Yes.
Whether legal or illegal is not a requirement.
Yes.
But Mr. de Kock thinks that it is a requirement and in fact criticizes the indictment for that reason. And it is upheld by the National Director of Public Prosecution.
Yes.
If you go to paragraph 6 of that judgment, page 4,
Yes. Yes, I see it.
so it talks about the definition of the word enterprise.
Yes.
Then if you just go further, 1, 2, 3, 4, 5, 6, the sixth line from the bottom of that paragraph,
Yes.
just read that. It says there is no,
Yes.
yes,
There is no requirement that the enterprise be legal or that it be illegal. It is the pattern of racketeering activity through which the accused must participate in the affairs of the enterprise that brings in the illegal element. And the concepts of enterprise and pattern of racketeering activity are discrete. Proof of the pattern may establish proof of the enterprise, but this will not inevitably be the case.
yes. Now, which answers two misconceptions in paragraph 190.1. Misconception number one is the idea that the enterprise must be necessarily unlawful. It's
Yes.
clear here that it must just be an enterprise, whether it's lawful or unlawful.
Yes, because sometimes a legal system
Yes,
is used as a vehicle to be an enterprise.
precisely, which is
Yes.
what Cato Mano was.
Exactly.
Yes. But they also answer another misconception, which is this enterprise must exist separately from the pattern of racketeering activity. When the judgment says proof of the pattern may establish proof of the enterprise.
Yes. Yes. The continuity, all those elements, the continuity, the structure, system of authority, all those requirements, if they are met, then they form an enterprise. Whether it's within an unlawful structure or a lawful structure,
Yes.
it doesn't matter, yes.
Yes. In fact, to show that this is not just a blab,
Yes.
they repeat it at paragraph 190.3 of the de Kock report.
Yes.
They say the statements do not prove that an organized criminal group existed that acted in common purpose and conspired together on a continuous basis to commit murder. So it seems their understanding is that the enterprise must be an organized criminal group. So at paragraph 190.3 of the de Kock report, SB 3202.
That is not true. If they have read the statements of the witnesses read, they would have realized that the killing of people, committing of offences continued. At least what is captured within the indictment is from May 2008 until September 2011. That shows a pattern of racketeering, continuous commission of illegal activities. So, and yeah.
Yes.
And there was common purpose there. All the elements are there.
Yes. And then You know, it actually gets worse.
Paragraph are you reading that refers to the common purpose?
Paragraph 190.3.
190. I thought you
190.3.
said 193.
No, 190.3, sorry. So I suppose let's just go through this again to make sure that we haven't missed important elements.
Yes.
So they say here the statements do not prove that an organized criminal group existed that acted in common purpose and conspired together on a continuous basis to commit murder. So there is a fundamental problem that Mr. Tikok believes and his team that in order to be an enterprise, you must be an organized criminal group.
Unfortunately, it's a lack of understanding then
Yes.
of how racketeering and POGA legislation provides and operates.
Yes. But we've just had a Supreme Court of Appeal judgment we've just read that
Yes.
says the enterprise can either be lawful or unlawful.
Yes.
Yes. Now, quite apart from the definition of the enterprise, they also seem not to understand the import of the term continuous.
Yes.
Apart from the decision of the Supreme Court of Appeal, the Act itself,
Yes.
on a clear reading of the provision, does it really speak of organized criminal groups or criminal activities? Because that's where you start.
Yes. Yes. What do you say?
Where could we find, I'm just wondering, where could we find in the POCA any suggestion that the definition of enterprise could encompass the phrase organized criminal activities by a group? Could there be such?
To say that the group must be organized.
Yes, to say that even apart from the decision of the SCA,
Yes.
upon a proper reading of the POCA,
Yes.
the definition of enterprise,
Yes.
where does it speak of such concepts
No, it doesn't, Chair.
that we find in paragraph 190.3?
It doesn't. The POCA definition talks about a continuous pattern of commission of illegal activity by two or more people in common pursuit or common purpose. It doesn't say it must be organized or it must be a legal entity, it must be an illegal entity or something like that.
Proceed, Councillor.
Yes, thank you. You know, I mean, this is this paragraph 6 of that SCA judgment. You know, it couldn't be clearer. It says it is difficult to envisage a wider definition. A single person is covered. So it seems every other type of connection between persons known to the law or existing in fact, those which the legislature has not included specifically, would be incorporated by the introductory word includes. So what we have here is we've got Mr. Tikok and his panel who just imposed their own requirements and ignored the requirements of the statute.
Yes. And if they had just sought the prosecution memorandum only, at least then they would have gotten the definition of hawker, racketeering and all of that, enterprise, everything. Then it would have been clear to them if they had not at least consulted the POCA itself.
Yes. They also seem to misunderstand quite apart. I mean, we've shown how they misunderstand pattern. We've also shown how they misconstrue the evidence. We've also shown how they misunderstand enterprise.
Yes.
They also misunderstand the concept of continuous.
Yes.
If you look at paragraph 190.6,
Yes.
they say if one has reference to the evidence as contained in the dockets, the alleged enterprise was on the verge of extinction. In 2011, the accused are only charged with 2 racketeering acts as compared with 9 racketeering acts in 2008. To show a continuity, the racketeering acts must include a specific threat of repetition extending indefinitely into the future. Now, what is your comment on this? That in order for it to be a pattern of racketeering activity, it must be unending into the future.
No, it must just show that within the alleged period, it had continued for some time. It wasn't just a once-off thing.
Yes.
It must have continued. That is why continuity is one of the prerequisites or elements for identifying an enterprise
Yes.
and a pattern of racketeering.
Yes. Yes.
So this is not correct. Besides, the indictment also says 2008 to 2011. That means the offenses, the criminal activities continued
Yes.
for those number of years. So the element of continuity has been satisfied.
Yes. You know why this is totally absurd, what they are alleging?
Yeah.
It means you can commit racketeering for 10 years. As long as you stop before you are charged,
It's not racketeering.
then it's not racketeering.
That is incorrect.
Yes. Yes. But it's also absurd. Now, do you know that actually this was accepted by the NDPP, Advocate Batoi?
Yes, it's on this basis of this report that she withdrew the racketeering charges.
Yes. Now, I had to go through this in detail at paragraph 190 because those are the reasons they have given for alleging that there is no case for racketeering,
Yes,
to just show how ridiculously absurd they are.
I agree.
Now, I just want to then look at the last part, which is, you know that the NPA has been relying heavily on the judgment by Judge Govan.
Yes,
Yes. To say that it gives them a justification to withdraw the charges, to push people like Advocate Jiba out of the system,
yes.
to push people like Advocate Chauke out of the system.
And they pushed me as well.
Yes, well, I didn't want to mention you, but because you are not a witness for yourself. I want to just go to that judgment. There are a few parts there that just show how they have abused that judgment.
Yes.
The judgment appears at CL2. I don't know if you've received a copy of the judgment.
Which file?
CL2, page CL00358. Yes, I'm told.
Yes, I have it.
Yes. If you can go to CL00358.
Yes, I have it.
At paragraph 27.
Yes, I can see it.
Yes. This is what the judge actually found, not what has been peddled in the newspapers.
Yes.
He says, from this, it can be seen that the NDPP says that she relied on information under oath and the evidence as contained in the dockets, and that the instances relied on her by her are referred to in the above-mentioned statements, which were considered together with the other information in the docket before the impugned decisions were made. Whilst she says that she will not detail all the information placed before her prior to making the first impugned decision, she does not say that any of that undisclosed information was relied on by her. In argument, the respondent submitted that because the correspondence annexed to the founding affidavit refers to documents which contain prosecution strategy and information concerning informers and sources contained in correspondence between the DPP and the NDPP, the inference should be drawn that those documents were also relied on by the NDPP. The insurmountable difficulty with this submission is that the NDPP does not say that she had regard to any such information or documents at the time the impugned decisions were made. She limits herself to the documents dealt with above Had she said that she considered such documents, even if the precise contents were not disclosed, this might well have affected the outcome of this application. Then he says, the provisions of POCA allow for hearsay and similar fact evidence to be led in certain circumstances. Once again, the NDPP does not indicate any reliance was placed on any such evidence. Now, what you find here is that this is an extremely narrow finding, which says, based on what you say you relied upon, we find that what you say you relied upon is irrational. It is not a finding of general import that General Boison is not prima facie guilty of the crime of racketeering.
Yes.
And in fact, it's stronger than that because it says POCA allows for hearsay and similar fact evidence to be led.
That's what I also testified
Yes,
to.
you testified on that.
Yes.
Yes, I remember. And then they say, if you had said in your affidavit, you've also relied on hearsay evidence
Yes.
and on similar fact, the
Yes.
outcome could have been different.
Yes.
Then if you go to the next paragraph, paragraph 38 at 00359.
Yes.
In paragraph 38, just the first line there, it says, I hasten to emphasize that this outcome is based purely on the facts of the present case. Now, we've just shown what those facts were.
Yes.
Then, paragraph 38, later on, if you go to where it ends, which is in the following page, 1, 2, 3, 4, the fourth line from the end of that paragraph. It starts with in the light.
Yes.
Can you see that?
Yes.
Can you read that?
Okay. In the light of the provisions of POCA, it is also not necessary to have beforehand sworn statements from witnesses on which the state intends to rely. I expressly refrain, however, from making a positive finding as to the level of disclosure necessary in meeting an application such as the present one or the detail required. This can only be assessed on a case-by-case basis.
Yes. So again, the judge is saying, look, you don't even have to have a sworn statement before you under POCA.
Yes.
Yes. But I am criticizing you because you say you relied on sworn statements. If you had told me that you are relying on unsworn statements, I would have decided the case differently.
Okay.
Yes.
Yes.
Yes. But the important point here is that the judge is saying it is not necessary to have sworn statements before
Yes.
the NDPP.
And that is true,
Yes.
because POCA allows that.
Yes. Now, this is the one thing I've never understood since I got involved in this case.
Yes.
Why the NPA leadership, not the prosecutors, have been obsessed about sworn statements of Mr. Danikas, when the judgment in 2014 already made it clear that it's not necessary to have sworn statements on a POCA prosecution.
Yes.
Can you explain why they've taken this?
I wondered as well.
Yes. Then, in paragraph 39, they say, it is important to note that the above findings do not amount to a finding that Mr. Boison is not guilty of the offenses set out in counts 1 and 2 and 8 to 12. Now, those are the 7 counts against him in the indictment.
Yes.
2 of murder,
2 of,
racketeering,
yes.
2 of defeating the ends of justice.
1 of defeating the ends of justice.
Yes.
And 2 possession of unlicensed firearms.
Unlicensed firearms.
And the
Under,
other
those are the
predicate offense.
violations of the Firearms Control Act.
Yes.
Yes. And then they say that can only be decided by way of a criminal trial.
Yes.
Then it goes on, setting aside the authorizations and decisions to prosecute also does not mean that fresh authorizations cannot be issued or fresh decisions taken to prosecute if there is a rational basis for this decision. So the judge never closed the door on the NPA
Yes.
to prosecute Mr. Boison again.
Yes.
My understanding of your evidence is that even today, as we speak, on the 6th of February 2026,
Yes.
the door is open to Advocate Motibi to charge Major General Boison.
Definitely.
Yes,
And other Katumena members.
yes. And then the last paragraph, which is paragraph 40,
Yes.
that last paragraph of importance for what I'm putting, not of the judgment,
Yes.
says that Prayer E in paragraph 3 of this judgment seeks to interdict the NDPP from issuing fresh authorizations in the absence of the NDPP having before her facts under oath implicating Mr. Boison. A final interdict is thus sought. The requisites for a final interdict are well established. A clear right must be shown, an injury actually committed or reasonably apprehended, and an absence of an alternative relief. Mr. Boison has a clear right to a lawful decision-making process. He certainly has no rights at all to such a decision being taken only if affidavits connecting him to the offences are in the possession of the NDPP. Now, the reason I mention this is that he tried to get an interdict in perpetuity, that he will never be charged.
Yes.
He failed. And then the judge says, I have mentioned above, for example, that hearsay and similar fact evidence is admissible under certain circumstances in respect of the offences under Section 2, subsection 1 of POCA.
Yes.
And then later on, in the last sentence there in that paragraph, sorry, the third last sentence, they say, to make such an order, now that's an order of a blanket interdict in perpetuity.
Yes.
To make such an order would amount to fettering the discretion of the NDPP to make the decisions in question. This discretion has been given to the NDPP by the requisite legislation, and there is no attack on the constitutionality of that legislative provision. No order shall therefore issue in terms of Prayer E. So it comes back to the point that he actually tried to put a blanket interdict, and he failed.
Yes.
And then they said, well, it's up to the NPA upon a reassessment of the evidence, including a reliance on unsworn statements, to charge him.
Yes. Hence the fresh racketeerings authorizations were issued again now in 2016.
Yes. Well, I mean, the reason we've had to go through this exercise is
Yes.
perhaps to answer my puzzlement
Yes.
at why Advocate Batohi placed any store in this judgment.
I wonder.
Yes. Thank you, Madam Chair.
Thank you, Counsel. Thank you, Counsel. Advocate, I was looking for you here. The three of you, who is really examining the witness?
Madam Chair, we had agreed that I will do it.
You are examining the witness. Please place that on record properly.
Thank you, Madam Chair. Madam Chair, we have agreed amongst us that I will do the re-examination, and I promise to be very, very, very brief. Advocate Nuko,
And whatever you have decided to do, bear in mind, as we discussed this morning, this witness should not be kept long. I'm not trying to limit your re-examination. She must be out of Gauteng as soon as possible.
hence I said I'll be very, very brief. Advocate Nuko, I in fact looked through your memorandum that you addressed to your colleagues. That was in October 2020.
Okay.
And when I read that, I would
You
have.
have to take us to the documents that you are referring
It's
to.
Annexa MN, it's MN 455, Madam Chair, to the witness statement. Yeah. 5. Are we there, Madam Chair?
Proceed.
Are you there, Ms. Nuku? Are you there on
Yes, I have it here.
Yes, just so for clarification purpose, you know that I told you, we don't hold the brief for anyone else, but we just have to make sure that the truth comes out. When one reads this document, one cannot help but notice that it comes from a painful place, in that it's preceded by a lot of vilifications as a result of a number of decisions that you took when you were a DPP in KZN. Would that be correct?
Yes, yeah.
And when one reads it, one finds that amongst the central features of the vilifications was General Boison.
No?
I say this because if you start on the Pandey case, General Boison was the complainant.
Okay.
Am I correct?
Yeah, he was.
And you took a decision not to prosecute Mr. Pandey,
Yes.
and
to
Mr.
withdraw the case.
and
yeah.
Boison wasn't happy about it.
Yes.
Yes. And also, you say that, in fact, there was an attempt to use your office on page MN0007 to use your office to kick out Ms. Nkabinde out of the way so that she's forced to resign, and thus General Boison becomes the next SAPS provincial commissioner.
No, I'm not saying that.
Let's just read that so that we clear that. It says, I have never seen or heard of any complainants doing this and having visitation rights to accused persons
Where are you reading?
at the top of MN 477, the top paragraph, Madam Chair.
Yes.
And then say, okay, I'll start again. It says, I've neither seen nor heard of complainants doing this and having visitation rights to accused persons so that persons in their own cases. This then tallied with what the accused mentioned in their representations, that they were being pressurized to do certain things, like firstly implicate the then provincial commissioner of KZN SAPS, Lieutenant General Mamonye Nkabinde, who was allegedly referred to as, I will not read that word for safety reasons, that had to be given in so that she is forced to resign and Boison becomes the next KZN SAPS provincial commissioner. Do you see that?
Yeah, yes.
And would that be correct that Ms. Nkabinde was the attempt was to implicate her in the Pandey case?
No. To implicate her in a separate case.
Yes.
Yeah.
But the reason you then say at the end of your memo, in the memo, that you can no longer keep quiet whilst you're being vilified. That is in the introduction, in fact.
Okay. What about that?
I'm just paraphrasing that by you writing the memo.
Okay.
You are trying to speak out after you say you have been vilified because of various decisions that you took. Am I
By
correct?
the media, yes.
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 And when I read your document again, when I stopped reading, I think General Boison is mentioned a number of times in the first few pages.
Advocate Mtsweni, I think it will be fair if you you don't just say General Boison is mentioned as if I have a beef with him. I don't. I don't know him. I've never even met him.
That's
I
not.
think maybe you should indicate where I mention him, the context why I'm mentioning him, and I will answer you.
No, ma'am. I'm not trying. That's what I'm trying to clarify to say. Would the criticism would it be fair if one was to say, when one reads it, it appears as if you have got a bone to pick with General Boison?
No, it's wrong because you must read the whole thing, understand, before you make that conclusion.
No. I'm not making it. I'm just trying to clarify, ma'am.
No, you're clarifying wrong because you must say it in the context of where you see his name. Tell me what I'm saying about his name.
In fact, it's for your own benefit, ma'am, so that in the future.
No, Councillor. You cannot argue with the witness.
I'm just trying
She's trying to answer your question. You're putting a statement to her and she's answering and say, no, this is not what I said. You have to read it in context.
Okay.
I think then you can take her to the context if you understand it otherwise.
No, we don't understand it. I just wanted to clarify it so that there's no criticism against her. In fact, in future, that she said all these things against General Boison because she had a bone to pick with General Boison. I'm just trying to clear the air in that regard.
Yes, but that's what she's answering. She said, no, she had no bone to pick.
Okay, thank you, ma'am.
Remember, she is the witness for this panel.
That's what I'm trying to
We
clarify.
will protect her if you seek to cross-examine her in that fashion.
No, Madam Chair, I'm not trying to do that. I'm just,
And
in
when
fact.
she answers you, pick it from the answer.
Yes.
Thank you.
Yes.
Thank you.
Now, Ms. Nuku, again, so that we're clear, I'm not sure whether you've got the Cock reports, the
Yes.
report. Can you just pick one of them
Yeah.
and turn to the last page, the second last page? I know that you've got two different versions,
Okay.
but the recommendations appear to be, the conclusion part seems to be the same.
Yes, I see them.
Now, yesterday, Advocate Nkabinde said to you that when he was trying to advance the argument of a single prosecution authority, to say, in fact, Advocate, no, in fact, I'm trying to remember, just give me a second, when he said the Cock panel, in fact, withdrew the charges, the racketeering certificates. Do you recall that?
No, they did not.
No,
they
I
didn't.
never said that as well.
Yes.
Please.
In fact, I can't find it on my notes. That's what I wanted to quote him properly.
The racketeering authorization charges or certificate was withdrawn by Advocate Batoy.
Yes.
You
Okay.
remember even as the days when the withdrawal took place?
Yes.
I don't remember the panel of the court withdrawing anything.
No, I just wanted to clarify that so that it's not seen as if I wanted to check whether did you understand the evidence to be saying it was withdrawn by the Cock panel or was it by Advocate Batoy? But I do recall the chairperson clarifying that with her. I'll just move on from that point, Madam Chair. Thank you. Now, I just deal with the last part, which you spent a bit of time with Advocate Nkabinde on the.
Sorry, as regards the earlier point, I might have missed it. You referred to the recommendations of the Cock report.
Yes.
Were you making a point on the recommendation?
The point we wanted to make was that the Cock panel did not withdraw; they simply recommended.
Oh, that's the same point.
Yes.
And you have corrected yourself now.
Yes. Now, the charges which both the racketeering as well as the predicate charges, they've got a timeline, it's from 2008 and 2011, am I correct?
Yes.
And one of the, insofar as the racketeering charges, one of the things you need to prove so that you must prove a pattern of racketeering activity,
Yes.
and it must be you in this case, because of the number of accused people, you had to, depending on whether they are charged under management or participation, you had to ask yourself whether each one of them there's evidence of participation in racketeering patterns.
Obviously, when you charge people in any case docket, you check whether there's evidence to prove what offense against whoever, then you charge accordingly.
Yes.
Yes.
Now, we know that in this case there were at least 2 racketeering charges
Yeah.
against Boison, and then there were other predicate charges.
Yes, 5.
And we know that the predicate charges stem from, I would call, the Magojela incident.
Only the men, yeah, okay, all of them.
All of them.
basically. Yeah,
So-
Makojela and Tembe.
That was one incident.
Yeah.
And he was not charged for any other incident.
I'm not sure if he was charged with the murder of Mr. Bongani Elfas Mkhize.
No, he was not.
As per the indictment, I don't have
No,
the
no.
indictment.
The only charge insofar as the predicate charges was the Makojela incident, which we know that it was defeating the ends of justice, murder, as well as possession of contravention of the Firearms Controls Act.
Yeah, times
So,
2.
yes. And we know that all those offenses stem from one incident.
Yes.
And other than that, there were no other charges that he faced on the predicate charges.
Okay.
Am I correct?
Yeah.
I'm asking this to so that I can find out from you as to what other evidence did you consider, or do you rely on in substantiation of your point that there was at least a pattern of racketeering, demonstrated evidence of racketeering pattern against Major General Boison?
He was a manager.
Yes, I understand.
No, let me explain to you. He was a manager of this unit since it started. And the commissions of the dates for the commission of the offense is 2008 to 2011. He's been all along managing the activities of this enterprise. So it does not mean only because the 5 predicate offenses happened on the same day, which was 16 September 2008, it means he's not involved in the others. By association, he gets joined into. That is why also POCA legislation allows what would be misjoinder under ordinary cases. Where you join people together, you wouldn't ordinarily do that under normal circumstances, but under POCA you do that. So he's joined into that pattern of racketeering that happened for all those years. And by association, common purpose is also there. So
But
the predicate offenses, it's only a requirement to charge with racketeering. It doesn't mean that he's not, he was not part of that pattern throughout those years.
Yes.
Yes.
And you're saying that his participation, his being part of those other offenses is through a common of doctrine purpose, right?
Yes.
But then the question is, why was he not charged with those other ones if he participated through the doctrine of common purpose?
That's how POCA works. You get joined in, not necessarily that you physically committed that, but by association, doctrine of common purpose, you are there as well. But it doesn't mean you were there, you committed, you did this. But because you are part of the enterprise, then you are also guilty of those as part of that is why you are prosecuted or charged together in the same case.
No, but I'm just asking, say, look, logically it would follow that you would have to be charged for the predicate charges as well because you participated through the doctrine of common purpose, or even on the predicate charges.
Yes, he was charged with predicate offenses. Maybe I'm not getting your question clear.
Yeah,
He was charged with predicate offenses, which are the prerequisites
But it was
for
one.
racketeering.
But it was one incident. The question I have is why, not in respect of everyone else, but only in respect of the Makojela case?
POCA doesn't say it must be 400 sins or incidents.
Okay,
As
noted.
long as the requirement is that it must be 2 or more offenses, then they meet the requirements of being predicate offenses. And once you have 2 or more predicate offenses, then you have met the requirement to charge in terms of section 21E or 21F.
No, I just wanted to clarify that. Thank you, Madam Chair. Let me just confirm with my team whether I've got there's anything I've missed. Madam Nuku, I was just being reminded to just ask you to pertain to page 70 of the DECOC report.
70.
Yes, bottom page 70.
Okay. I see it.
Page 70 or paragraph 70?
Page 70, Madam Chair. Are you there?
Or the pages at the bottom?
Yes. Yesterday, you agreed with Advocate Nkabinde when he criticized through you the DECOC panel for not having gone in depth in the analysis of the dockets. Do you recall that?
Yes.
Now, I just want to check whether you still agree with his contention if you start under paragraph D from page 1, from paragraph 191.
Okay.
And where you would see, if you go through it up to page 91, if you go through that, you would realize that the DECOC panel, in fact, did analyze the case dockets, and they tell us what they are about. Do you see
Which
that?
paragraph are you referring
From
to?
191 to
Page 70? Is it
paragraph 191.
191 up to?
It goes all the way to paragraph 229.7.
I feel it's very superficial and I don't even believe it.
No, but
Because
the
they
point.
should be saying exactly
Please
what
allow
each
the
docket-
witness to answer
Okay,
you.
thank you.
You don't have to interrupt
Okay.
anybody.
Okay. I'm just saying that, in fact, the statement put to you by Advocate Nkabinde, which you agreed with, was that, in fact, they had failed to analyze each docket like you did. All they did was just to do a laundry, to provide a laundry list.
No. The issue was that there are some dockets that are missing where there are no explanations or analysis on. And if you are referring me to paragraph D up to 191 up until where you're referring to, I will still say it's very superficial. You cannot be relying on this to make a decision. For you to make a decision, you must go thoroughly into each and every case, analyze it. Then you will be able to know, with a fine-tooth comb. Fine-tooth comb, yes. You must go through that and be sure that you... So this is a very superficial analysis that one cannot rely on to make a decision. More information was needed to know about these cases, to make a decision to withdraw the racketeering charges and all other charges predicate and the rest.
Okay, I've got no further
So it
questions.
was on that basis that we're saying they did not read the dockets.
Okay, thanks for the clarification, Madam Nuko. Thank you.
Thank
I've
you.
got no further questions, Madam Chair.
You also look at paragraph 191, the one that we've just referred us to. Just that paragraph. Look at the words in emphasis. Those underlined words emphasizing that there was no shred of evidence linking them to any offense. In the next line, it says they also allege that the accused also killed civilians and
One looks at it, there appears to have been as tangible evidence to note of the ultimately that is the question for the panel to answer, because that is what Advocate Chauke is accused of doing, that he made some of these decisions where there was no evidence. And I think at this stage, Madam Chair, I wouldn't want to be seen to be.
yes, but you are an evidence leader. You know these records better than us, as you presented the evidence in chief. Now, I'm asking you that now that these reports are not even giving us the summaries of the dockets, you remember Advocate Bartoi said she didn't read the dockets at all. She relied on these reports. Do you remember?
I recall that, Madam Chair.
Now, this very report upon which he relied do not even give us a summary or summaries of any of those dockets so that we can have a sense of whether the contents of the dockets were considered to make a determination whether there was a case, prima facie case or not. So without that, and somebody comes and say, from the look of this report, which does not even summarize, not even in one line, just simply giving us a broader picture without summaries of those dockets, upon which Advocate Bartoi herself said, I didn't read the dockets. I relied on the DeCock report. But the report does not give anything insofar as each one of those cases, the 23 dockets, are concerned. And I'm asking you, as you lead, and that will help us, because the terms of reference suggest that there was no evidence.
Madam Chair, can I get?
No, wait a minute. This very question comes from the very paragraph you drew our attention to. And I'm saying to you, as we ultimately have to decide that point, and of course you will argue it, but now that you raised it, I'm asking you, could it ever be correct, now having even looked at the summaries, that you don't take issues with? And we know that the report that was relied upon does not even give summaries. They emphasized words without shreds of evidence linking them to any offense. What do you make of that?
Madam Chair, can I confer with my leader before I make that concession?
Yes, if you can't assist me, it's fine, I understand.
I do not want to be seen to be not willing to make a concession when I have to, but given the fact that there are still going to be witnesses that will still come to and talk to the report.
You may confer with your colleagues.
Yes.
I thought that if you would be able to help us because you raised the point.
Madam Chair, the guidance I get from my team is that whether the reasons are sufficient or not, it's for the panel to decide. But what we have is, when you read from paragraph 191, yes, emphasis is made that there was no tangible evidence whatsoever, and they give reasons why they believe so, and from paragraph 192, 191, 193 downwards. And on those bases, that's what Advocate Patoy says she relied upon. And I think it's something that we can, with the panel's leave, should be considered against the totality of the evidence of all the witnesses that would still come. And then that's the question that I'll gladly answer during argument, whether after the evidence has been laid. But if Chair can pinpoint me, then I will answer that question at that point.
We know that we have to write to make a recommendation and an assessment eventually, but I raised it because you referred us to it.
I appreciate that, Madam Chair, and it's something that I'll ponder on moving forward, knowing that I owe the panel an answer, a simple, straight answer on that.
May I comment, Chair?
Wait a minute, commenting on what?
On the very same issue, if I may.
Which issue, Madam Noko?
The very same issue in paragraph 191. What my view is with this underlined writing.
Well, I just wanted counsel to
Oh,
assist me because they are leading the evidence, and he raised the paragraphs. So I'm not sure whether you really want to go there.
Ms. Noko is a witness, Madam Chair.
Should she do?
No, she's a witness.
I think you can do that.
Thank you, Chair. I just wanted to say this actually proves that they did not read the dockets. Because anyone who read the docket wouldn't say there was no shred of evidence, wouldn't say there was no tangible evidence, with all the evidence that is fully in that case.
You got it, Advocate Mchene.
That's Advocate Nogo's conclusions, Madam Chair. I'll still give my submission later on. So I think, Madam Chair, that from our side, that's all. Unless the panel has got more questions for Advocate Noko,
Yes.
then she may be released.
Yes, thank you, Advocate Mchene. My sister reminds me, actually, our researchers noted the matters outstanding that were to be looked into, including the withdrawal of the predicate offenses by Advocate Harrison. Did you find that information, Advocate Lekgetho?
No, Madam Chair, I'm informed that the dockets will have.
You may speak into the mic, please. Please.
I'm informed by NPA that the dockets themselves will have the inscription by the prosecutors for withdrawal of respective dockets. And Advocate Zungu,
Advocate Harrison now.
oh, thank you, yes. She has written a report to the NDPP. They were looking for it and they will make it available.
Which would tell us about the withdrawal of the predicate offenses.
Most probably because they say she indicates what happened in each docket.
Yes, please don't forget.
Yes.
Another matter pertains to the list of accused persons and their numbers. You remember during cross-examination this issue arose and the list was to be compiled.
I think it was for Advocate Mutsweni, Madam Chair.
Yes. Advocate Muchweni.
Can I provide it tomorrow on Monday, Madam Chair? Because I must have missed it, but if the chair wants, the numbers, does the contact numbers or just the charges?
No, not contact numbers. Advocate Muchweni, you're here this morning, please. You remember the cases in respect of the accused persons?
Yes.
Spoke about that, so if you can give us a list of those accused persons and their numbers.
We will
The
do
case
so.
numbers.
So, meaning the dockets under which they were charged, etc. That can I provide? I'll provide. I'll put that
I have
information
to go
together.
back to my exact notes as regards precisely what we said we should do.
Remember, there is somewhere where they are listed as accused 1, 2, and we couldn't identify actually who is accused 3, accused 5, and if memory serves me right, accused 6 was skipped. We need to know what happened. Accused 12, and from accused 17 to accused 20-something, there were gaps. So that is the list that we would like to have. If somebody is deceased, it should be accused number so deceased, and then we will know so that we can cross-reference whenever accused are mentioned.
Okay, we'll do so, Madam.
Maybe to help you, the transcript will be available soon. You can go to the transcript and just check precisely what we want you to do in relation to that issue. So the transcript will pick it up and provide that list on Monday.
We'll do so, Madam Chair.
Not tomorrow. Tomorrow is Saturday. You can file it and we will have a look at it on Monday. Don't forget, please.
Chair, thank you.
Advocate Nogu, there's a question that Advocate Mutsweni asked about charging the persons that were suspected of having committed the relevant offences.
Yes.
And the focus of that question was about the fact that General Boison was the manager, right?
Yes.
The manager, in terms of your assessment, he was seen to be the manager of the entire enterprise.
Yes.
Right. Now, the question that he asked, and I don't think I got the answer or I understood the answer that you gave, and I'm asking it again just in order to understand clearly what your answer is.
Yes.
Now, the question was that regard being heard to the fact that General Boison was the manager,
Yes.
how come that he was not charged in respect of all the offenses with the others? Regard being heard to the fact that, I mean, it is on record that Boison was the manager. Even at the time when Ayer was on the seat, he was on the seat but not on the operations. He remained the de facto manager of the enterprise.
I'm not sure how to answer this. He was charged with being a manager, 21F, and 21E being participating. So that participation relates to all other offenses. But then the requirements for racketeering, for predicate offenses, relates to the other 5, count 8 to 12. So he was not charged for, say, count 21 somewhere in the indictment per se, but he's part of the whole thing. Like he's part. I don't know how to explain it. Yeah. But yeah.
Maybe let me say.
Yeah.
I understand. I think everyone that has been sitting here understands that.
Yes.
Looking at the evidence presented thus far,
Yes.
he was part of this enterprise.
Yes.
Right? But then the question just relates to regard being heard to that.
Yes.
Be it in predicate offenses or even in the racketeering itself. Why is it that he is not the common co-accused in all the cases? I think if I understood what he sought to get was that, and if I'm wrong, nevertheless, I would like to know and understand.
I
Thank
get
you.
the question now.
Yes.
Thank you, ma'am. Count 2, section 21A, covers that he's participated in the commission of the offenses, in the racketeering. So count 2, the racketeering one, covers that because he participated. The title of the charge is participating in the illegal activities. So it's covered there. So you don't necessarily charge him with possession of a licensed firearm in another there. You just concentrate on the requirements of racketeering. It's possible to charge a person only with being a manager, as long as then the predicate offenses are there, 2 or more. But then with regards to Major General Boison, it's not only being a manager, but also participating. So that participation relates to all other offenses without him necessarily appearing in every count. It's covered under participation.
Right. Thank you. I think you've clarified.
Thank you, ma'am.
Okay, Mchwane, that brings us to the end with this witness.
Indeed, so, Madam Chair.
Advocate Nkabinde, you have had your bite. Yes, thank you. Advocate Noko, we, the panel, take this opportunity to thank you for having made time, 3 days, to come and testify at our instance.
Yes.
We thank you and would like to excuse you so that you can travel to wherever you're traveling safely before dark.
question.
Once again, thank you. We wish you well.
Yes, I would also like to thank the panel, the enquiry, for giving me an opportunity to come and assist them as well, and also making my stay here secure. I thank you.
We thank
And
you. You are
everyone.
excused, madam.
Thank you.
We have some other business to deal with as you leave.
Madam Chair, I just wanted to indicate regarding what the panel also raised in relation to the outstanding issues.
Yes.
The MEC's affidavit, it has been reported to us that I think the NPA team has difficulty finding that affidavit. Remember the MEC's affidavit in relation to the Mkhize case. I just wanted to say, because that might be relevant to this witness while she is being excused. I'm not sure.
I'm not sure. The witness just left now. Yes, I remember that that affidavit of the second respondent in the Mkhize application, that interdictory application by Mr. Mkhize. Well, if it cannot be found, it cannot be found, I suppose. If it can be found later, I don't think the witness can say anything about it, because those are the questions that arose from us. I wanted to see what was referred to in that paragraph by I think General Boison, referring to that affidavit. But let's leave it there. If you cannot find it, you can only do so much. We will make a note. Thank you, Council. We'll leave it at that. And the matters that you raised this morning in chambers, was it for a private meeting or you'd like to raise it here? But before we get there, you owe us a report as regards what you were going to do when we postponed a matter a week ago regarding whether a conflict of interest has arisen. And I reminded you yesterday, Advocate Skosana, that remember, your witness is still under oath, under cross-examination. We have not been told by you as to what we are to do or to make of the fact that that witness has not come back. When is she coming back, if she comes back? How far are you with your intended approach to the minister regarding that purported conflict of interests?
Yeah, Madam Chair, the report I have is as follows, that that issue has to some extent been resolved, and I've been informed by the NPA team that she has now been granted permission to appoint a legal team, shall I say an attorney, who will then appoint counsel for her to assist her in relation to the legal counsel that she requires. And that has only occurred, I think, yesterday, so it was reported to me. And I am not sure whether that counsel has now been formally appointed. And I discussed it with
Advocate Hali earlier on, and when we actually thought it will be part of our report in chambers, where he will also participate in giving that report, the finer details of what is happening.
Suppose you were advised by advocate, your attorney, the state attorney.
The state attorney.
The state attorney.
I was advised by my state attorney, yes.
Shouldn't you get further instructions from the state attorney? Mr. Semele Meja is here. As to, we need to get details because we have to move forward. It's not enough to be told that he has now been afforded an opportunity to be assisted. Then the question arises, what then? Because we are still waiting. Somebody must tell us when she's going to come and take the seat, the witness seat. When will that be, if she intends to come back? Will we know when? Mr. Semele, you are the state attorney.
Chair, I was informed by the head of the office, Mr. Chowe, yesterday night that the NPA ESCO has since taken a decision to afford the former NDPP with a legal team of her choice. So what is going to transpire is, because I'm the attorney for the evident leaders, there's an attorney, Mr. Matuba, for the NPA. So he's the one who's going to appoint a private attorney, who in turn is going to appoint a counsel of Advocate Batoi's choice. So I'm not sure if that process has been finalized of date. I'm not involved in that process. I was just informed because I had to update the evident leaders. Yes.
May we request you, and I'm sure I'm speaking on behalf of my sisters, let me just confer with we request that you request Mr. Mutuba to be here on Monday, 8:45, and give us a report. A full report, because we need to know when we should expect this witness to come back and testify.
Thank you, Chair. I'll do so.
Yes, thank you. Another matter that you were to raise in chambers, Mr. Skosana, was it the matter for chambers deliberations, or you want to raise it here?
Would prefer to raise it in chambers, Madam Chair.
I hope it's not a matter that is going to detain us for the better part of this afternoon, especially because we don't even have an idea what it is.
We think not.
And all councils will come to chambers hereafter, and we will listen to you. Tell us about the process. We postpone this matter to Monday. What is
Yeah.
happening on Monday?
Well, Madam Chair would suggest, subject to the panel, to stand it down, for us to have that discussion, which we hope it won't take long, and then the way forward will be.
And
charted.
come back.
Indeed.
Yes, thank you. We'll adjourn for a few minutes and reconvene.